Got those going. All right, so after all of the happiness that we've already endured this morning here to get us to 9:34, I think we are ready to get rolling. And so I'm going to officially call us to order at this point. This is a hearing before the City of Tacoma Hearing Examiner in what pre-hearing submissions have billed as, well, there's a whole bunch of stuff, but I think the hub of the wheel is the preserved preliminary plat, which was received into Planning and Development Services, or as I'll refer to them in short, PDS, land use file LU 22-0244. And when it came to us, we assigned a hearing examiner number HEX 2024-017. Attendant to the preliminary plat, and this is something that I'm going to want the parties to put on the record. And Louisa, for these, because my mic's probably picking me up, if you could put those more towards the middle of the table so we're picking up the parties a little better. Because once I'm done with all of my blah blah blah, they are the show. And I've got my other mic here, so let's move those just briefly. But while you're doing that, I'm going to continue with the introduction here. Attendant to the plat, because when you have something like a plat that requires a public hearing, and by public hearing in today's sense, I mean it's a public hearing in that anybody can log in, come in, participate, but it's also public hearing in the sense that we take public comment, public testimony. All hearing examiner hearings are public in that they're open to the public, but not all of them are open for the public to participate. This is a public participation hearing. And when we have one of those, like a preliminary plat, or also like a major modification to a PRD overlay, which is essentially handled as a rezone proceeding. Rezones we also take public comment, public testimony on. So attendant to the plat, we've also got that major modification to the existing PRD overlay, which I heard back in 2020. And then the council decided, because it's a zoning action, and I don't decide zoning actions, the council does, but I hold the public hearings for the council on zoning actions. And so just for everyone's edification, so we're all on the same page, I am the decision maker on the plat. I am not the decision maker on the PRD. I do make findings of fact and conclusions of law that become a recommendation to the council. Now, I do have a question on that, though, because this is a major modification. On an initial request for a PRD overlay to be put in place, that is a council decision, is treated as a rezone. This is also treated as a rezone. But I would love to hear from the city on whether the city thinks I am the decision maker on a major modification to the PRD as opposed to initially putting in place the PRD. I've been over the code. I'm not sure it's entirely clear, but I'd love to hear the city's position on that while we're dealing with procedural matters on the way to getting underway to taking testimony on this. Mr. Harala, do you want to weigh in on that at all?
Yes, I can give you the Planning and Development Services take on the code, and certainly if need be.
And hang on just 1 second. Is everybody in Zoom land hearing Mr. Harala okay? Andrea Myers, you want to be my tester there again, since you're my office staff, remote? You're hearing Mr. Harala okay? I mean, you're not now because he's not talking.
I will try to project too. I have a notorious problem of not being picked up on mics, despite my being kind of having a loud voice. So for folks to hear, Larry Harla, Principal Planner, Current Planning, City of Tacoma Planning and Development Services. So to answer your question, Mr. Hearings Examiner, again, from the planning staff perspective, you are the decider. In that, typically these would flow to our director if there was just a standalone major modification.
Not tacked on to the plat.
Yes.
Okay. Well, I kind of read the code that way too, but nevertheless, we treat it like it's a rezone. I'm gonna withhold my ruling on that. I think I'll make the decision, and if I decide that it still needs to go to council, it'll go to council. honestly, whether it's a decision for me or recommendation for me, I approach it the same way regardless. It's just whether I get the final say or not. But I think I read the code that way too, that if it weren't for the plat hearing, this would just go to the director, he'd be deciding it, and it wouldn't go to the count, wouldn't go back to the council. And I think that's probably right, but I'm going to withhold ruling on that until I issue my ruling on it. So we have the preliminary plat. We have the modification to the PRD. We also have a critical areas minor development permit and also a site plan approval, if I'm reading the pre-hearing submissions correctly. So here's my question on that. Is the site plan any different than the proposed preliminary plat, or are they one and the same at this point?
The staff view is that they're one and the same at this point.
Applicant have any different views on that? Okay, because I didn't see anything in the submitted materials that this is the site plan and here's the proposed preliminary plat. So that's why I assumed that they were one and the same. Now, for everybody who's listening that is not an insider on this, the only reason that I'm deciding this whole enchilada today is because the preliminary plat requires a public hearing, and I'm the guy who conducts those for the city when there's a land use action involved. The only thing that public testimony is supposed to be taken on is the preliminary plat. If someone applies for a site plan approval, there's no public hearing on that when it's done as a standalone. The same is true for a major modification to a PRD. The same is true for a critical areas permit of whatever nature. If those are done as a standalone, there's no public hearing on them. There's no testimony on them. In fact, if someone applies for a critical areas development permit as a standalone, the director decides that, the Planning and Development Services director decides that, and if the parties don't like the director's decision, it gets appealed to me. It's not on appeal today. I'm deciding in a first instance because it's all glommed onto that plat. And the reason that we're doing a plat here is because the new plat for the preserve is so very different from what was approved by me back in 2020 with a different applicant and a very, very different arrangement. Well, same in some respects, but different in enough respects that we're doing a new plat here rather than trying to modify or amend that old existing plat. Correct?
Correct.
All right. So we've got that all sorted. Now here's the additional fun kicker. Because this is a plat of more than 20 lots, it required a review under the State Environmental Protection Act, or SEPA. And that SEPA review was done. And when it was issued, it made it so that the appeal deadline was actually, if we want to go at on an actual full 24-hour clock, less than 2 days before this hearing. And we got an appeal of the SEPA mitigated determination of non-significance, the MDNS, late in the day on Tuesday. And that is the applicant appealing it. And the applicant is challenging a couple of conditions that the city imposed, mitigation conditions that the city imposed in issuing that MDNS. Normally that would be all heard together. And I will note for the record that the applicant has weighed in saying it wants the MDNS appeal heard today. I know the applicant didn't create the timing situation with this. The city did. And for future reference, you'd make one hearing examiner who will remain nameless very, very happy if we didn't have these kind of tight timelines with things. But city, you created your own problem because your legal counsel wants to be representing you on the MDNS appeal, and he's not available today, as was noticed out by my office yesterday in the afternoon. So, like I said, normally the MDNS appeal would be heard as part of all this. We actually had one of these back on the 29th of August where there was an MDNS appeal for a little bit smaller menu of items, but we had a plat and we had a critical areas permit, and then we had an MDNS appeal. And we heard that as a discrete part of the day's proceedings at the end of it all. because just like the critical areas permit and the PRD modification and everything else that's not the plat, we don't take public testimony on an MDNS appeal. If council had been available today, we would have probably heard the MDNS appeal at the end of everything today. And the applicant, if you want to make a record on it, if you think you might have an appeal issue for that later on down the road, but I am going to grant the city's request to have the MDNS appeal continued until council can be present. And if you want to make an objection to that on the record, you certainly can. But I think it's fair for the city to say we want our legal counsel to represent us on that. Now, noting for the record that the city is the one who created the timing issue by issuing the MDNS at a point where the appeal period was going to end less than 2 full days before this hearing today. But it doesn't surprise me at all, knowing Mr. Victor's existence, because he took my place in the city attorney's office, and I know what a harried existence he lives in because I used to live it for 8 years. It doesn't surprise me at all that with less than 2 days notice, he's not available for this hearing today. Applicant,
yeah.
Do you want to make a record in regard to my saying that I am going to postpone the MDNS hearing until such time as the city can be represented by its council?
Sure. Evan Mann with Copper Ridge LLC. For the record, we do object. We would prefer that it was all heard today, but I understand the conditions or the situation that's been created by the city, and recommend that SEPAs be issued well in advance of hearings from here on out. But that's obviously
that makes 2 of us.
Yeah, it's a silly process.
Yeah, it doesn't make any sense to rely on that there are not going to be any appeals and have the appeal period butting up to what otherwise is the subject matter that normally the MDNS appeal would glom onto, like everything else has today. I will tell you this, ideally, and my office staff needs to check on this. We need to check on everybody's availability, but ideally, in my world, we would hear the MDNS appeal next Thursday. I don't know if Mr. Victor is available then. I don't know if all you applicant folks are available then. But in order to not let more grass grow, more time elapse, and all of that, and I know that the timing probably is the biggest issue for you as the applicant. Ideally, we would hear it next Thursday.
I have the calendar up.
Yeah, we don't have anything on for next Thursday, do we?
No, we're fine. And Mr. Victor has something at noon, from noon to like 4, radio service consolidation.
So here's my next thing then, and it's a question. Applicants, are you available for it next Thursday if we can get the city here and present?
As it relates to the appeal, I think the only representation we would need would be myself, possibly my boss, and then Craig. I don't. Well, it is a condition from traffic. You're potentially available. So if you're available next Thursday.
He's available.
Pre-noon.
Okay.
I'm available. Oh, there's one. Yeah. Available. Okay. You're good, Aaron? Right? So, all right. Applicant's team is available.
And because that is not a public testimony hearing like the plat is, we could hold it entirely remotely if you want. You don't need to come here again. That would be my preference. I have no problem imposing that on the city. But my guess
The city
is
would request that we have a conference that significant numbers of staff will be able, remote attendance would not be a problem whatsoever. So
okay,
we'd prefer that actually.
That works for us.
Yep, and we'd probably be able to start on time.
We'll watch for.
I just got a comment from
invite from someone.
One of the city's witnesses. So the city's traffic person is out of town. Anyway, we'll get that sorted and scheduled after this. But I just wanted to say, ideally, that's when I'm going to want to hold it. Yeah.
I'm a neighbor, Steve Jeffries. I live at 103 East 82nd. For the people that So this hearing next Thursday is different from the hearing that was today.
Yes.
So it's not, so it's gonna be on,
And there's no public comment
I know,
taken.
but what is that meeting for? What are you sorting out?
The city, state law requires for a plat that exceeds 20 lots to have an environmental review on it. The city did that review. The city issued its determination, and that the city issued what's called a mitigated determination of non-significance. So what it means is, if you do these mitigating measures that the city's environmental staff, and then ultimately through the Planning and Development Services Director issuing the decision says needs to be done, then we say there is no significant environmental impact from this proposal. And the proposal, honestly, is the later development. It's not creating the subdivision map. So it's kind of weird in that it's looking at a snapshot in time of the plat, but what's going to come later. And so the city issued that. The applicant is not appealing the determination, but it is appealing a couple of the conditions that the city placed on there as mitigating conditions. And so the parties to that proceeding are the city defending its decision and the applicant challenging two of those mitigating conditions. And so the only people we take testimony from are the parties, because it's an appeal hearing. And because it deals with the same subject matter we're dealing with today, normally it would be heard as part and parcel of this. But the only reason I'm feeling like we can separate that out is that all the language in SEPA, this is for you applicants, since you're objecting to postponing it. All that language in SEPA says if the underlying action, in this case the plat, is being appealed at the same time as the SEPA determination, they have to be held at the same time. You're not appealing the plat. So it's not an appeal, it's a public hearing that normally we would attach the appeal to, but I think under the circumstances, I have the authority to continue it. And again, noted under your objection. And if you decide to appeal my determination on the appeal of the MDNS, you could make that an issue too if you want. Yes.
So you're at the point where you're gonna have this hearing for the MDNS to this continuation, and then there's gonna be another hearing?
Nope.
Based on?
Nope, that's it. Today and the MDNS appeal.
So what's happening today?
Today, I am hearing presentations from the city on
So
the
you're-
plat. Maybe if they decide to give me additional information on the critical areas development permit and the PRD modification, all of that will be heard today. We'll hear from the applicants on that today. But the only part of today's proceeding that is open for public testimony is the plat. That is the only part of this that I take public testimony on. A lot of times people who come from the public don't really limit what they have to say to the plat itself, because that's, sometimes because they're just not following the rules, and other times just because they don't really know where one ends and another begins. And sometimes I have to say, you're crossing over into other areas, please keep it to the plat. But that's all that we take public testimony on, is the plat.
Yeah, as a neighbor and a citizen, I think the confusion is jargon that you guys use internally.
I
Plat,
understand
mean,
that, yeah.
plat, it's the jargon.
Yeah.
And
the plat
the
is
acronyms that you guys use that the public isn't.
Yeah, and unfortunately, if we're down in council chambers or if we're entirely on Zoom, the folks in Zoom I can still do this for. I could share it up. But what the plat is what Mr. Deaver is holding up right there.
Yeah,
It's saying, here's how we're going to subdivide this property in order to develop later. And then you've got a copy of
I've
it.
got
So
all
that's great.
the documentation that's available,
Yeah, and
but not modification. Not what you talk about.
yeah, folks out in Zoom land, I would really appreciate it if you did not use the chat for any purpose other than if I ask you to respond in there, because it gets very distracting. And I saw that the last message was that someone was waiting to go in. I know that. I let them in. So please, if you would not use the group chat for any purpose other than what I specify. The only purpose I'm going to specify is to sign up to speak when we get to that portion of the hearing. So we've been very scattershot to this point. We'll try to focus us back in here at this point, if I can talk. So again, we are here for the public side of this because it's a plat hearing. That is all. But because the critical areas minor development permit, PRD modification, the site plan approval, all gloms onto that, I become the decider of first instance on those, as opposed to normally it would be the planning and development services director. And then if people aren't happy with those, they would appeal them to me. But we lose that layer because of the glomming, I'm going to call it today. So how we're going to proceed today is we're going to hear from the city first. The city will make its presentation on the plat initially, hopefully. And they'll present on that. I will note, though, for everyone who's participating today, I have 670 pages worth of submissions that came in essentially from the city, of everything that it received and reviewed on the way to scheduling this hearing before me. And let's just address that at this point now so we can get it out of the way. That has all been received into my office and marked as, they're all open now. Let's collapse down here just a bit. And when it collapses down, it collapses everything. Because it's just that kind of day. They have been marked C for city, city exhibits C1 through, if I get down all the way to the bottom, C12. That sound right, Mr. Harala?
That's correct.
And the city provided the applicant with a copy of those, much of which probably came from the applicant as it made its application and the review of that happened. Applicants, I presume that you have a copy of the city's C1 through C12. And who's the voice today for the applicant?
Craig Devers will be the lead, and I'll be backing him up with applicant and then
Okay.
representative
Consultant.
engineer.
So you're the voice then. I'm asking now then whether the applicant has any objection to the city's C1 through C12 coming in being made part of the record.
No, we do not have any objection. For the record, I'm Craig Deaver, principal at CES Northwest.
Okay. And you'll be the main voice for the applicant.
Yes.
All right. So, Mr. Hurrell, I presume you want to move to have those admitted and made part of the record then.
Correct.
All right, and that will be granted with no objection from the applicant at this point. So my point being then, now that those are admitted and made part of the record, all of that is part of the record. It does not have to be read in today. It does not have to be completely testified to today to be part of the record, part of what I consider for the plat, for everything that relates to the plat, for the critical areas minor development permit, for everything that's part of the record that relates to critical areas development permit, for the major modification to the PRD, and for the site plan. It's all there. It's part of the record. Now, we do have public comment today. And the reason that I have public comment go after the parties make their presentations is so that people who are here and are interested in the plat, they may be interested in the whole of it, but testimony is on the plat. The presentations by the parties help, I think, to inform those members of the public better what's going on here. I have the authority to take that public testimony up front, but then it's imminently less well informed when it's made. It probably doesn't change anything. I don't know, but I think it's better to be informed. So members of the public who are here to testify, you'll have to bear with us. We're going to hear from the city, then we're going to hear from the applicant, and then we will take public testimony. Now, the applicant has the right to cross-examine any of the city's witnesses once they're done putting on their direct testimony. That's time to ask questions. It's not a time for you to testify or say, here's why we think you're wrong or any of that. It's just a time to ask questions. That's what cross-examination is for. When cross-examination is done, if that city witness has some things that need a little further clarification that came up in cross-examination, we can do that and take redirect testimony. Once the city is done, then we'll move on to the applicant. The applicant, you can put on your witnesses. Nobody's represented by counsel today, so we're not going to do it in question and answer. You can just testify. All right. If you were here represented by counsel, I'd probably want your counsel to be eliciting the testimony that's necessary, but we don't have that luxury today, or that annoyance, depending on how you do it. I don't know. And you know, when I say sort of semi jesting, you know, poking things at attorneys, please note that I am one of those too. So, you know, it's a self-indictment to a certain degree. When the applicant is done putting on its witnesses and testimony, and if the city has cross-examination, it can do that just the same as when the city puts on its case. Then we will move to public comment, public testimony. And here in the room, I think I've only got one person. If you signed up on the sign-up sheet already, so we've got your information, you're wanting to testify, correct?
Correct.
When we get to that point, you can do it now, I guess, if you want, but people who are out in Zoom who are wanting to testify, please put your name and your contact information into the chat. That's the one thing I want to use the chat for today. And that will be how you sign up from out in Zoom to testify when we get to that point. I'll remind you when we get to that point. We'll probably take a short break before we do that. So you'll have time. If you want to do it now, that's fine. You know, if you wanted to testify and not give us your name and your contact information, I guess you can do that. But it kind of goes to the weight if you want to identify yourself and sort of say why the plat, you know, is important to you enough to come and testify today. And if you want a copy of the decision when it comes out, I got to have your contact information, or you'll just have to get it off our website like everybody else does. So, geez, we're an hour in already, and we're already getting through the procedural stuff. Thanks to the delay of council chambers, but whatever. Can't do anything about that because it's not my room to run. Are there any procedural matters from the parties that we need to address before we get underway at this point? Is there anything from the applicant? No. Anything from the city?
The city has them.
Okay, the last thing that I need to know is that for everything today, the applicant bears the burden of proof to show by a preponderance of the evidence that the plat meets the criteria for approving a preliminary plat, that the critical areas minor development permit should be issued, that the major modification to the PRD should be approved, that the site plan should be approved. And later on, when we do the MDNS appeal, you bear the burden of proof there too. And we'll talk about that when we do that. We're not going to do it today because I've already made my ruling on that one. I will note that preponderance of the evidence standard, we have people in the waiting room again now, so hang on. I guess we have people leave and come back or something. I will note that the preponderance of the evidence standard in the various legal standards, of course, because it's today. Preponderance of the evidence standard is not a high burden under the law. It's not like in a criminal proceeding where the prosecution must show beyond a reasonable doubt that the elements of the crime were in fact committed. Preponderance of the evidence is basically, you got to tip the scales your way. Okay? So it's not a particularly difficult standard to meet. And in the case of the preliminary plat, because of controlling case law, it's even less of a standard to meet because our Washington state courts have essentially said that if the applicant can show that by the time the plat is final, they will meet all of the requirements, all the things for which they have to make provision essentially, that they are going to be able to do that. And if the city doesn't have any evidence that contravenes that, or if the city is actually saying, no, we think they will be able to meet all of the city standards and the applicable state laws and regulations that apply to this kind of a plat, if the city is saying too that they think that the applicant will be able to meet those standards, you're essentially good. But keeping in mind, I know the applicant knows this, I know the city knows this, a preliminary plat is just this. And the decision will say that it's a preliminary approval. It's no guarantee of anything but it is an initial statement if it's approved saying it looks good so far, essentially. And we think you're on the right path. And that's pretty much about all it is anymore. But you have the burden to show that, and meaning the applicant. I gotta realize I'm not on camera here, so when I point to you, it doesn't mean anything. The applicant has to show that. And I will note, though, that the applicant is entitled to rely on all evidence that is either in the record now through the 670 pages of city submitted exhibits, or that will come in as part of the presentations. Meaning that when the city's witnesses testify, if you're good with that testimony, you're entitled to rely on it. If you're not good with it, you'll address it when you make the presentation. All right. I think that does it for me. Still no procedural matters, questions from the applicant at this point?
No.
None from the city either?
None from the city.
All right. I will note that all testimony given today is made under oath, so I will swear you in. Both sides have the opportunity to make an opening statement before you offer testimony if you want to do that. If you're not sure what would be opening statement and what would be testimony evidence, I can just swear you in and we'll just go. All right. We are to the city then at this point for presentation on everything, but I'm presuming the plat first. We'll start with that. Are you wishing to make a separate opening statement before testimony, Mr. Harrell?
I do not.
All right. Are you the first witness for the city?
Yes, I am.
Would you raise your right hand, please? Let me try to catch that on the screen so we've got it for the video record. You swear and affirm that the testimony you're about to give as part of this proceeding today will be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do, Mr. Hearings Examiner.
Go ahead.
All right, so I will, in the interest of saving us time, do a really quick opening, if that's all right with you, Mr. Hearings Examiner.
I asked if you wanted to do an opening. You said no. I thought we were going straight into
I will
testimony.
apologize. So my testimony.
No, that's okay. I'm just razzing you. Whatever you want to say at this point.
Yeah.
I'm the one ultimately has to determine what's just statement, argument, and what's evidence, and I can do that pretty well after 30 years. So
Okay.
go ahead.
Thank you, Mr. Hearings Examiner. And I will try to be brief here, as you have already very well outlined most of the aspects of this, and I fully concur with everything you said relating to the application before us. And I also want to just note on behalf and for the applicant that the burden is on them, and so I want to kind of keep my stuff brief so they have more time to kind of get to all the things they need to. So we do have in packet C1, and I don't know how you're doing it today per Zoom.
Well, I can share them for the Zoom folks. You guys aren't going to have the benefit of my share
Sure.
screen, so
I
you
have
have to rely on your own.
C1, and I have made the applicant aware, should they like to reference any of the, I just have some screenshots and a PowerPoint that for reference during the course of the proceeding here. If
So,
anyone,
and that's fine. And I'll want to have it up on my screen, so I may as well share it for the folks in Zoom land.
yeah.
So you tell me where you want me to be.
So we can really quickly be on slide 2. I'll just,
Slide 2 of your PowerPoint.
of the PowerPoint, correct?
Okay. So I'm at the PowerPoint. I am sharing it now.
I've got it.
I am on. Hang on just a moment. Everything's so wonky. I got to change the page and split it. A single page view. Back to the PowerPoint. There we go. The overview slide, right?
The overview slide,
All right,
correct?
we're
And
there.
I again, won't spend a lot of time here. I concur with everything. I think you really covered this entire the overview very well. I agree with everything that you said. The only thing I will add here, I'll add at this time, I guess, some housekeeping items, just most.
So keep in mind what I said is not evidence.
All right, so I will then quickly, what is before you is the 100. So I'll take some time to do a little bit of housekeeping while I do this slide. So I have 127 lots. We, through some of our public notice, had noticed at 127 lots. As you already nicely referenced for us, this is a process, this is preliminary, and as we go, their staff review and the applicant, of course, is going to discover things and decide that they need to change. So through the course of this preliminary review, we've gone from 127 to 119 lots. The packet is correct generally. The site plan, the survey document before you is at 119. That is correct.
Okay.
Some of the
So
exhibits.
the plat exhibit that I have
C3.
is the latest and greatest.
It is.
Because I need that. If that,
Yes.
I need to have what I am approving preliminarily, yes, but I need to have the latest and greatest in front of me as the exhibit.
Yes, it is. It is Mr. Hanks' examiner. It
Okay,
is correct.
so the slide is incorrect. The preliminary plat that I am now, that's in front of me now for approval is only 119 lots.
119 lots. Some of the exhibits, and honestly, I don't have an exhaustive list for you. It would be a little too numerous to 100% guarantee that I got it all right. We'll have a reference here and there to 127. The city's perspective and view on this is that is not material. 119 to 127 is actually a reduction across the board in general intensity. Key features of the plan have not changed. We don't have a problem with it. I'll defer to the applicants as they have their chance here in a bit to address this if they would like. But I just want to put that out there for the public and in case you have any questions on that. So that's one of the housekeeping items. We kept it at 127 through the SEPA notice, everything, because the initial notice was 127. In my experience as a staff person throughout my years as a planner, this isn't that unusual. We certainly see plats go down in particular in lots. As there is quite a bit of complexity with civil engineering and stormwater management and all that sort of thing. So that's the first housekeeping item. I will kind of call myself out. There's a few errors in my staff report. I have some exhibits.
Let me just ask one question quickly.
Yes.
When you said that the change from 127 to 119 is not material, I want to just ask about that because I want to clear for the record. I want to clear for my mind. When you say it's not material, what that really means, if I flesh that out, is it doesn't change the city staff recommendation on anything that's in front of me.
Yes. And if you'd like, I'll answer, I'll give you clarity on that, a little bit more detail. So
Okay,
when I
that's
say
fine, but-
material, what I mean is we don't need to renotice it. It doesn't change the level of application, if you will. It doesn't somehow bring this into a short plat or something like that.
No.
So the application doesn't change. We are not mandated by state or city code to do a renotice.
And it really doesn't change staff's recommendation
It-
or analysis for the most part.
It doesn't change
correct?
staff recommendation or analysis.
Okay. That's what I heard when you said it's not material, but I wanted to make sure that
Yes,
we have that spelled out in fine point for the record.
yes.
Okay. Go ahead.
And so in the staff report, I have, and I, just an error on my part, some of my exhibits are incorrect because I moved some folders around last minute. So per your preference and or your staff's preference, I am more than happy to submit an amendment that wouldn't have any change to text or anything at all. Just sort of we have folders referenced in a couple of the sections that are incorrect. So
Well, if along the way you wanted to change all the 127s to 119s, that'd be good too. And so I would actually prefer it if once we close the hearing, that the city would clean up everything that needs cleaning up in the record and just resubmit corrected record.
absolutely, Mr. Hearings examiner, I believe in the staff report, we have caught it, but I will double check everything as a matter of when I go back to make any corrections to make sure we don't have any 127 lot reference in the staff report proper. Now, we do have some of the study documents and the exhibits which the applicant has provided, which I feel it would be challenging and probably a little unfair to the applicant to ask them to go back and amend some of these reports that do go back now several years that are still accurate and still very useful in terms of our assessment for critical areas and that sort of thing. So those will remain at the 127 reference in places.
Yeah. Well, and the decision will reference the change. So the decision kind of, hopefully anybody who is insane enough to, go through all of this after the fact, or if there's an appeal of things or whatever, my biggest concern is if there's an appeal of it when it gets to Superior Court, that there's confusion when it gets to that point. And they're not taking new evidence. They're just deciding it based on the record below, unless there's extraordinary circumstances. So having a corrected record is great for me, but let's address that again when we get to the end of the hearing.
All right, Mr. Hearings examiner, we ready for that. And I just also want to reiterate on that we did really in the staff report in particular, try to make sure that everything is referenced in 119. And that we did confirm that the survey document and the site plan that you have is the correct the correct document. So I think
That's the big
those
one.
were our big concerns, certainly. So to move forward, really, the city, if you will allow, will may we use your introduction as far as just the application explanation, or would you like me to do that again on the record?
Well, I mean, for purposes, you mean just for purposes of what the whole compendium is today?
Yes.
That's fine. That's not really evidentiary anyway. I mean, we had to have that sorted before we got going, so that we knew what the whole scope of the proceeding was today. So,
If you're all right with that, then I'll move on from this slide and we'll just sort of talk site and just orient folks to our site, which would begin on the next slide.
we're there. The top is the preserve, right?
Yes,
Slide
correct.
3.
And so that just kind of orients us in the city, where we're at in the city, and then kind of gets up on the screen that we are dealing with a number of parcels. This is property that was sold, I believe, in 2018 by Tacoma Public Schools. It was purchased by a previous developer with a plan to do a PRD, which has already been referenced. There's the previous PRD, which was approved by the city and went through the full process, including city council approval. And that, so this is the property. I guess we could go to slide 4, and again, I don't have it delineated here. The purpose of this slide is really just to kind of get us focusing on what we're looking at. So Charlotte's Blueberry Park, Tacoma Metro Park, basically a 20-acre site, is directly abutting to the north, which on this map here, for anybody watching, I guess the screen orientation would be the right-hand side. 72nd, you'll see there is the north. And this site is sort of a flag-shaped lot with approximately 28 acres in it. About 18 acres of the site is going to be preserved, not to, hopefully won't continue making the pun, but I think it's a really good name actually, because 18 acres of the site is supposed to be retained and preserved as critical area. And then approximately 10 acres of the site is proposed to be developed, which we'll see on the next page, which is the plat layout, which we've been referencing so far. 119 lots in this configuration, where we have sort of multiple access to the surrounding road, and we have a substantial portion of the site which is not going to be developed in a way that will impact the 4 regulated wetlands on the site and the some acreage of biodiversity corridor that's also on the undeveloped portion of the site. And I will on the next slide. This gives us a little bit more idea of sort of the wetland presence, some of the wetlands here, and then just sort of where the property line is, the divide between Charlotte's Blueberry Park and the subject site under your consideration.
Get reoriented here. Yeah, tool doesn't work, and then I try to use the slider bar, and it jumps 5 pages on me. All right, so I'm on the wetlands and buffers, slide 6.
And yes, and so a big part of this consideration has been critical area evaluation and the minor development permit for the site. A substantial portion of the backup material and the exhibits is devoted to the critical area evaluation for the site. And that's been done, I would say, very thoroughly at this point, because we've been through it for the initial PRD, and then the applicant went through the time and the expense and of bringing in consultants to really continue doing that work and to do it relative to the new proposal. Just a quick statement on PRD. So the planned residential district in our code is sort of a unique section in our code, in that we are outside of the sort of normal zoning code standard for underlying zoning.
Yeah, well, it's an overlay.
It's an overlay. And while the R2 zoning under the underlying zoning does come into play in cases. There's certainly going to be, they're still going to have to comply with aspects of the R2 zoning. But the PRD really is, if you will, just maybe an easy way to put it, almost a mini master plan, in terms of, the applicant is making a proposal and the city considers it, and then we decide if it meets the code, and then we condition it accordingly. We have done that, and staff finds that the proposal, we have a recommendation for approval, and we do find that if the proposal with our conditions, it certainly does meet the PRD intent and the PRD code. We tried to go through in the staff report and link this back to our comprehensive plan and then to some aspects in the zoning code.
So let me just interject with a quick question. The biggest deviation in my mind then that the PRD allows that the R2 without the PRD overlay would not is the density that's proposed, correct?
Yes.
But then I also read in the city submissions that if the entire area of the site were taken into account, this density would still be allowed under R2, but the presumption would be that the density would be spread out over the entirety of the site as opposed to just 10 acres of it. Is that correct?
Yes, the city would agree with that, Mr. Hearing's examiner. I will actually add a little to the end of that though, and that the biggest deviation here, which is allowed under the PRD and that you would be approving, is the lot area. And so
because it's smaller than the
it's smaller
typical
than
townhouse
yes.
classification.
Yeah, and so we would have a limitation of a 3,000 square foot lot. And in this case, there's certainly many lots that are at or above 3,000 square feet. But some of the lots are as small as 1,500, a little over 1,500 square feet. And then the average is more like 2,200 square feet, which is something that the PRD envisions. And actually the point of the PRD is to allow developments like this to happen so we can get a site like this developed that would be otherwise exceedingly challenging for an applicant to kind of come in and come up with a project that would work.
Right, that's at this level of density.
Yeah, at this level
Again,
of density.
circling back to the density. Quick question for you. Home in Tacoma Phase 2. Would that change anything with the density that would be allowed here in terms of what's being proposed?
No, it wouldn't. In this case in particular, because there is an open space comprehensive plan designation for the site, it hasn't been redesignated. So this site wouldn't have been one of the sites that would have been swept into a UR2 or a UR3 designation, which is what they would need to do a development like this. So in a way, I guess from the staff perspective, it's kind of a good thing because the applicant's
so
not.
still need the PRD.
They would still need the PRD, and so it's not one of these kind of redundant exercises. Since you asked though, if you would like, I can maybe talk to Home in Tacoma.
No, it's okay. It's okay because it's all forward looking and kind of speculative anyway. But because Home in Tacoma 2 is looming at this point and is looking at maybe being approved by the first part of next year, I wanted to see whether that would have any effect on this. Now, you brought up the open space designation. It's designated. And disagree with me if I'm wrong on this, but I want this on the record because I end up having to address it in the decision. This property is designated parks open space in the comp plan because it's not developed and it's all trees and there's nothing else there, correct?
Correct. And also I just would, as I mentioned, the original ownership of this was Tacoma Public Schools, which by course, the city would typically designate a school site as parks and open space. We don't have the nuance.
So the designation is almost vestigial in a way, isn't it?
It is, but the city would say the portions of the site that's very appropriate, right? We're talking about conserving 18 acres here. And so for those portions of the site, absolutely. I think in my staff report, I tried to sort of make at least comparison for the rest of the site to like a low scale residential. I think if we had nuance, I would totally concur. Mr. Hearing's examiner, that probably portions of the site that the developer wants to develop would have some sort of low scale residential designation.
Okay. So last bit on that then for clarity of the record and for my mind and everybody who's listening, even though that property gets designated parks and open space in the comp plan, that does not prevent it from being developed, correct?
Correct.
And a comp plan designation is not a specific applicable to permits land use regulation. It's just sort of a policy statement, or in this case, it's more kind of just a recognition of what it was at the time the designation was made, correct?
Correct.
And if the city were to say, no, whoever owns that, whether it's a school district, whether it's then, you know, the party that bought it in 2018 and got the original PRD approved, or now the applicant, Copper Ridge LLC, the city can't say, no, you can't develop that property where it must stay as parks and open space without running the risk of, well, never mind. Nothing in that comp plan designation prevents the owner from developing it.
Correct. And I would even go further and say that there is support in the comp plan, even in open space, and sort of an understanding that because we have such a spectrum of sites that are designated open space, that we certainly do have sites like this, where a portion of the site being developed like this is absolutely something that is not at odds with the comp plan. So, yeah.
All right. Continue. I mean, I'm not totally done, but I'm done with that.
I think that I am really close to being done with our opening here for the city. Mr. Hearing's examiner, I guess if we want to just look at the final slide here, 7, just if nothing else, to make everybody in the room aware that this is here, in case we need to reference it later. And this just to kind of drive home the point of the complexity of this site and what the developer has to go through really to kind of develop this site, is there are 4 wetlands on the site. And, you know, the developer has to do substantial, really kind of complicated stormwater management and engineering and all those things to really kind of make it work for their development, and also to kind of keep the site whole. We also have a drainage feature, a city storm drain feature that runs diagonally across the site. So it's challenging for them. This is the kind of calculus of development, if you will. They have a lot of work that they've done and they have to do. And that I will also just reference that makes it challenging for the city as well to kind of really, as you in the opening expressed, at a preliminary stage without all of the sort of civil work and everything done to sort of make recommendations. It does put us in a challenging spot too as a city. But to your point early, just to kind of reiterate that as well, the city's position is that you know, this is viable, and that, you know, going forward, that, you know, at this phase, at the preliminary phase, the city's position is this, that, you know, that this can be something that can be done, and all of our codes may be met, and that's why we have the recommendation, staff recommendation for approval.
And as proposed at this point, the city has no life health safety concerns with what's being proposed. And as you just said, it looks for all the world like all the regulations will be applicable to this. By the time it comes in for final plat and through the development, will be able to be complied with. Is that correct?
Correct, with all the conditions that we have for conditions of approval. Correct.
Okay. Let me just ask you one more before I'm done with you, and then we'll see if there's cross-examination from the applicant. Again, I'm referencing the PowerPoint that was part of Exhibit C1, Slide 7, the wetlands and buffers titled slide. Down there on kind of towards the lower left or lower right corner, there are 2 areas where it's shown there are some red perimeter areas on the wetland buffers there. Are you following me? The arrow pointing to one of them says buffer average reduction 141 square feet. Then there's the other one below that, buffer average reduction looks like 1,845 square feet. Are you with me? Is it the impact to those buffer areas that was the reason for needing the critical areas minor development permit?
But not entirely. I mean, it's development of the entire site, which contains quite a bit of critical area in it.
Okay, and
So
actually it
this
looks
is
like there are a
certainly part of
couple
that.
other buffer areas that are impacted up on the top as well.
Yeah.
So I missed those. So those are all part of it as well.
Yes, I mean, the entire site, they've done a lot of work, as did the previous applicant, sort of assessing the rest of the site, those other wetlands out there, there's definitely going to be mitigation across the entire site that the applicant is going to be responsible for and has proposed to do to meet the critical area code. Because again, we've got the wetland, the buffers, restoration. We had to do. I mean, there's been wetland delineation, a lot of evaluation on this.
Yeah.
Um,
Well, I saw it the first time in 2020 as well, but I think at that point, the city wasn't requiring a critical areas minor development permit. It was just a delineation that went through at the time, if I'm remembering right. And I did look back at some of that because I was there for it. Okay, but the city is satisfied. The city made the determination that a critical areas minor development permit was required. But in the city's analysis of that, the city staff has determined at least that they've met the requirements for granting that, correct?
for granting, as you mentioned before, for granting, yes, and for granting the preliminary plat.
And for approving the modification of the PRD,
Yes,
correct?
that's correct.
With the statement that I'm the one who ultimately decides those at this point, at this stage now, but if it were left to city staff, you would be you are recommending approval of all of those.
Yeah, correct.
All right.
I have one more thing that I'm remiss on, Mr. Ainsley, if I may. I do want to talk about, the public comment. We definitely received public comment. We received about 10 public comments on this. Just to quickly summarize, and this is in the packet, a few things. I actually was contacted this morning, and I just want to say to anybody who's on Zoom or listening or maybe testifying, some questions about, hey, can we see the public comments? We don't real-time share out information that we receive. It's after your decision. We typically put that in a publicly available way on our file sharing program, so folks can certainly see that. The public comment itself received was pretty homogenous in terms of just like everybody had really kind of similar comments and with concerns expressed about loss of tree canopy. So we do have a condition in there nodding to the public concern about loss of tree canopies. And then just sort of generally lamenting that, hey, this is a nice undisturbed site. We don't have a lot of that in South Dakota. So that would be the only other thing I wanted to add before I'm done with this portion.
Is there cross-examination from the applicant for Mr. Hurl?
Yeah, I just had one comment since the SEPA
Not a comment, it's gonna be a question.
It's a question.
Okay.
Since the SEPA was approved for 127 lots, we're proposing on our plat map currently showing 119. If there was a way to achieve an additional lot or two to get not to exceed the 127, would that be allowed by city staff?
City staff, I mean, I would sort of reserve and look back to our hearings examiner, because really we're at the stage now where the decision is not with staff, it's with the hearings examiner. So I would say that is more a question to the hearings examiner.
Yeah, we're in the hearing. If you wanted to continue the hearing and renotice it and revise the plat map to add in a few more lots, that would be the avenue for that. After the preliminary approval, if the plat is preliminary approved at 119 and you're in the process that happens between preliminary plat and final plat, if and this is just kind of off the cuff, but if you were to find a way to add a couple lots back in somehow and the city staff were okay with that they would have to make the determination whether they thought that was a material modification to preliminary plat and had to come back to me or not.
Right.
But if they determine it's not material, it's the tree that falls in the forest and I'm not around, I would never even hear it.
Understood.
And then just to finish, I guess, along the lines of what you're saying, Mr. Hearings examiner, if I can, that is 1304, there is a process for plat modification, as there is in the RCW. So, you certainly could engage in a standard plat modification process, which there is some room for things like that to occur. So,
no more cross-examination
questions.
questions. And Mr. Hurl has basically already given us his redirect on the cross. City's next witness then.
The city will call no further witnesses at this time. We definitely have staff available and waiting to get into traffic engineering, site development, any questions on building or any questions that we have on critical areas. We don't want to make that have any more testimony.
And again, as I've said in prior hearings, you've heard me say this before, Mr. Rala, how the city chooses to present its case is how the city chooses to present its case. I usually don't interfere with that greatly, even though I can say, well, you know, I have questions on the record submitted. I'd like to hear from the traffic engineer or Ms. Kluge on the critical areas development permit. But honestly, I don't at this point. I've been over the written record and well, I shouldn't say that. Actually, there are a couple of questions that I think I have, but I need to go back through the record and find them. So bear with me for just a moment. But I'm not sure that that's going to necessitate calling other witnesses at this point. But before I let you off the hook, Mr. Ferralla, so I'm going to stop the share here. Well, I'll leave the share up. It's okay. Folks that Zoom on to see this. I am in section F of the staff report, if you wanted to go there. And the first section there is on the major modification, revision to permits, including zoning reclassifications. You started off there by saying major modifications shall be processed in the same manner and be subject to the same decision criteria that are currently required for the type permit being modified. So to sort of cut to the chase with that, your job in assessing it, city staff's job in assessing it to this point, and now my job in deciding whether to approve the PRD major modification or not, basically makes me have to go through the criteria for a rezone in 1305 and say, does it meet that? And then look at the criteria for the PRD major modification and make sure it meets that. So it's sort of like starting over. There really isn't a whole lot of benefit that the applicant gains by having a different PRD proposal and a different PRD overlay in place, because like you pointed out, the PRD is essentially sort of a mini master plan. And the mini master plan for what Green River Homes or something that folks I heard from in 2020 wanted to do. That was that one, and this is this one, and basically we're just sort of starting over on the PRD front, essentially, aren't we?
Mr. Examiner, correct, and I would say that it's a two. If you may give me a little leeway on that, just to kind of, it's a double-edged sword, right? A little bit too, as far as they don't get credit for the previous, but they're not bound to the previous either. We do sort of start over again.
Yep.
And yes, as included in the staff report, you go back through that criteria and they have to fully meet it. They don't get some sort of a bonus or a pass because we've had a previous rezoning action.
Right. And obviously, applicant, if you disagree with any of this, you can address that during your presentation, but I'll have you wait until then. Unless my additional questioning has brought up cross-examination questions you want to ask. So that takes care of that one. I'm now on page 14 of 38 of the staff report. And this is in the district development standards, subsection 6. I'm at paragraph, I guess it's, I don't know how that outlining even makes sense, but 6.7b. A lot of the outlining in the code doesn't make sense to me, but whatever. There's a reference in there in the fourth line to leasehold area. Is that a typo? Is that left over?
I will call
from
myself in on
before?
that. That's a typo, yes, and that would have been typo from some of the probably language from the previous PRD.
Right, because the previous PRD, they were going to do long-term leases of the houses
Yes.
they were proposing to build, is my recollection. So I thought that might be just a leftover. And the applicant can certainly address this, but Mr. Carl, your understanding is that the townhomes that are proposed for development under this plat and PRD modification, if everything gets approved and they're built, they're going to be sold to people to own them in fee, correct, rather than long-term leases?
Correct, and to be platted, and the previous PRD was a shared ownership situation.
Okay. All right, that takes care of that one. Let's see, what was this one? Oh, okay. And you kind of addressed this, my last question, still on the same page, the second paragraph of D there on the density. Is PDS taking the approach that under the PRD umbrella, I have the authority to approve the smaller lot sizes without a variance, correct?
Correct.
PRD
It's
gives me that
effectively
authority.
embedded in the PRD in your decision.
Okay. Just wanted to ask that and make sure it was on the record. Then I'm on the very next page. What's my question here? Oh, we've already addressed that one, so that's okay. That's the open space issue. I think that may be it, but give me just one more second to finish scrolling through. Let's see one. I do read all this beforehand. So. No questions for myself, but I had to make sure I hit while we're still have you on the stand, as it were. The stand being that section of the table presently. All right, I think that's it. Did my additional questions prompt any additional cross-examination from the applicant?
No, sir.
Okay. All right. So I guess then the additional city staff who's here, their utility in remaining, and they're all going, we have to stay. I think you probably should, because there may be rebuttal that they would have testimony to offer on. And that rebuttal may come from things that the applicant brings up in its presentation. It may also be things that come up during the public comment, public testimony portion of the hearing. So with that said, if the city is choosing to rest at this point in its initial presentation, we would move to the applicant.
You will rest.
All right. Who's on first for the applicant then? Mr. Beaver. All right. Let me readjust the camera here. And you're tall, so I got to tilt it up a little bit even. There we go. You swear and affirm that the testimony you're about to give as part of this proceeding today will be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
Go ahead.
Good morning. I'm give a brief summary of the project and kind of go through my notes here, and feel free to stop me and ask questions during my testimony at any time.
You know I will.
Absolutely. My name is Craig Deaver. I'm principal at CES Northwest. Our firm provides civil engineering, survey, land planning, erosion control services. We're here today to represent the preliminary plat of the Preserve PRD. It's a townhome development and it's on behalf of Copper Ridge LLC. CES prepared the preliminary plat package and submitted to the city of Tacoma. I'd like to thank, first I'd kind of like to thank city staff, Larry in particular. We worked very closely with Larry on this, Carla, Joy Rodriguez, Jennifer Camerzell, Mika Hoppin, Lyle Halstein, and Dan Hansen, just to name a few. I appreciate the presentation completed by Larry today. And as you noted, and as Larry mentioned, the city staff recommends approval of the project. However, as we will go through there are a few sections of the staff report and ultimately the recommendations that we would like either clarified and or revised if possible, and it'll be done through my presentation and through my team, the rest of the team's presentation. The witnesses today, we have Evan Mand here to my left, Kurt Wilson behind him, and to my right it is Jeff Malahan and Aaron Van Eyck. And Jeff Malahan's with Wetland Resources, and he'll handle the wetland and buffer and some of the hydrology questions that may come up. And Aaron, of course, is with Heath and Associates, and he's available to discuss any traffic or traffic calming issues or any concerns that arise that are related to that.
But let me just interject really quickly in terms of for scope today.
Mm-hmm.
We have the two conditions from the MDNS that have been appealed.
Mm-hmm.
I certainly have no problem if you put on the record that you're contesting those conditions. The heavy nuts and bolts of that probably should be addressed when we get to the MDNS appeal hearing.
Yes.
So I don't want you to think that if you don't go into the full presentation on those today, that will then you'll lose your opportunity for that, because we are still going to have the MDNS.
Understood. Quick question. Those are just related to the two conditions that are in the MDNS that we have right at the moment. So
anything else that's a condition of approval of the plat,
right,
or the critical areas minor development permit, or the PRD, if those are specifically being presented by the city for me to act on as conditions of approval for those three things, you should address them today. And I know those two MDNS conditions have probably been imported into the conditions for the plat, but they are imports.
Right.
So we don't need to go into the full presentation on those two necessarily today.
So can I ask you a question?
Sure.
So
As long as it's procedural.
the MDN, yeah, it is procedural actually. The MDNS, you will issue the MDNS of the appeal, denial or approval of, at the same time that you issue the hearing examiner decision. Is that correct?
Maybe, maybe not. Ideally, probably, but I will tell you, I'm going to work through the plat and the other stuff first.
Well, they're tied together. We would just not like to have the, anything that's in that may change as part of the staff report and the conditions.
If you'd prefer that I wait and issue them all when they're all done, I can honor that, because the timing of things, really is your concern and your right at this point, as opposed to anything the city would be complaining about.
Yeah, I think to have them issued at the same time would be fantastic. So you can consider both of them, so we don't have some crossover issues between the two.
So no.
Well, if
Well,
why don't you go through yours and I'll
right,
yeah,
back
no
to
worries.
you go
Okay.
through yours.
Okay,
then
no, okay.
Let's take
So-
everybody discreetly. I don't want to be
Yeah,
ping ponging back
understood.
and forth. If we
Thank
have
you.
it.
So the project consists of 8 tax parcels, as Larry indicated. So the total site of all 8 parcels is approximately 28 acres, almost 18 acres of wetland buffers and associated open space. So the primary development of the 119 units will be located on 10.37 acres, which if you go to slide 3, I believe it is. Can you go to that slide really quick, Evan?
Slide 3 is the
Exhibit
PowerPoint.
C3.
It's sheet C3.
Exhibit C3.
Yeah, exhibit C3. It's PP1 sheet. And so that's the
So
overall site plan.
Exhibit C3.
Correct.
Yes. Sorry.
If you got all
Well-
of the exhibits in a large PDF like we did, it's page 70.
I'll try that. But I have very little faith that it will work. No, page 70 for me is a picture of the notice sign in the back for pickup.
That's next. Go to next sheet, very next page. 71.
73 for me.
Okay.
And let me blow this up a little bit before I share it so that folks on Zoom can see it.
Looking at PP1s.
Just want to make sure everybody has a visual of this as I go through it.
The hand tool just doesn't work right because it just wants to. Yeah, it's such a pain. Try to blow things up a little bit, and I can't move them without it. Hand tool just doesn't work. All it wants to do is highlight things. Well, I'm there, you're there.
Okay.
I'll try to make it as best I can for the folks
Fantastic. I appreciate you
remotely participating.
working through these conditions. So, again, the development is 119, which is located on the primary, the easterly portion of the site on the 10.37 acres. And it's important to note the previous development had structures on there that have been or will be removed during our site development process. So they'll either be relocated and or demolished. I don't know if the decision's been made on how that exactly is.
What are those?
They're existing homes that were going to be used for.
Oh, that's right. That's right. They had a demo. And
Yeah.
Okay.
Yeah.
Okay. I know what you're talking about. Then.
As previously discussed, the parcels are currently zoned R2 with a requested plan resident, a PRD, a plan residential development. It's within just an overlay, this is kind of confusing, which makes it an overlay R2 PRD and is within the Parks and Open Space Comprehensive Plan. So I think you guys touched base on that earlier, and we're in agreement with that. I just want to make sure we got the designation that's correct. So there are a couple other things. We as part of the research that we completed on our team, there are no known existing wells or individual septic systems on site that are affiliated with the existing homes. But if we do encounter something that's on site, we will decommission and in accordance with the health department to come out Pierce County Health Department standards. So, the site is bordered on the east by East D Street and the south by East 80th Street. There are single-family homes beyond the roadways. The site is bordered on the west by single-family homes and a church to the north by Charlotte, and to the north by Charlotte Blueberry Park. So it's important to note that the Blueberry Park is to the north of the site because of the connection, the trail connections that we're making, and then some of the other amenities that we're providing as part of the development. Those will kind of incorporate some crossover pedestrian access. We're enhancing the existing stormwater easement that has a road down it that's going to become a trail and also be used, that utilizes an access for the storm and still be used, kind of a dual purpose trail system. We completed a boundary and topographic survey. This is on our preliminary plat sheet PP2. I don't know if you want to try to bring that up, but it's there if you wanted to see it.
Is that the next page?
I don't know if it's the next page. It might be. Anyway, on that sheet PP2, which is our existing conditions map, which shows the boundary, the wetlands, the topography of the site. You'll notice that there's a few encroachments, and almost the entirety of those encroachments are located in and near the wetland tract. So there won't be any direct encroachments with the proposed lots. It'll all be, there's some fence encroachments, some yard areas that are encroaching into the wetland and wetland buffers. So the site does contain, as we discussed, approximately 18 acres of wetlands, but more somewhat important to mention as well is that there's a biodiversity area in there as well that has been delineated and accounted for in the wetland and biodiversity reports that were provided. Our biologist, which is sitting off to my right now, can speak to that as well. It's important to note the site plan shows 20 tracks. However, 5 tracks and there's 5 tracks and 10 were not used. The reason that's important is we're not sure exactly how the tracks are going to be delineated on the final plat. We're not sure if each wetland is going to be required to provide its own tract, or if we can provide the whole wetland mosaic and the open space all in one wetland tract, and then maybe sub out those wetland areas as easements or some other delineation method. It is our preference to have it as one large tract. That way we're not setting property corners for each little individual point that falls within the tract areas. Excuse me, the wetland areas that will fall within the tract.
But that wouldn't change anything with the delineated
No,
areas of the wetland and their buffers and any of that.
It's just, it's a simple fact of how it's shown on the final plat map at the end of the recording.
Right.
So I'll go a little bit into townhomes. So the townhomes are a mix of 4, 5, and 6 units. The maximum number of connected townhome units is 6, with a minimum spacing of 10 feet between the actual buildings. So each unit will have 0 lot line, but when the buildings end after 4, 5, or 6 units are attached, there will be at least 10 feet between each one of those buildings. The maximum building height is allowed to be 35 feet. And again, this is building height calculation will need to be established by the existing grade as determined at the time of final plat. This is something that we will work with through city staff, but we currently believe that our finished grades as proposed and the buildings that we're proposing will meet and be under that 35-foot height restriction. The setbacks that were noted on the project are 20 foot for the front yard, 5 foot for the side yards, and 10 foot for corner lots, and 10 foot for the rear. So the corner lots are the ones that are on the corner of a street. Those will have a 10-foot side yard setback, or however you want it. We call those interior setbacks, but it can be determined for a corner lot setback as well. All the proposed townhomes are set back 20 feet from the front property line to provide for landscaping of private yards and porch areas. The end units for the townhomes will include side yards. I'll touch a little bit on parking. 4 off-street parking spaces will be provided, 2 in the garage and 2 in the driveway for each lot. So there's enough room for that as well. On-street parking is also provided on throughout the roadway system. There's several areas where the bulb outs are that will accommodate parking.
The street width pretty much uniformly throughout the development is proposed to be 28.
Yes.
Paved surface.
Yes. However, there are areas where there's traffic calming, where there's bulb outs that narrow
That's right.
down.
Those would be the areas where that would
limit the parking
be
area.
smaller.
Yes. Let's see here. There was one comment on that had notes that there's a missing middle housing are mentioned as duplex, triplex, and four. So this missing middle housing is in the range of, there's sort of some commentary in the staff report about missing middle housing, and so we believe that this will meet that standard. So I guess I'll just go on. The city of Tacoma encourages development of the missing middle housing to fit diverse housing opportunities, which utilize in this proposed development while creating a walkable neighborhood within a half mile of transportation, retail, and dining along Pacific Avenue. Open spaces and accesses to community such as Charlotte and Blueberry Park to the north. So we feel like this project meets that criteria that's set forth in the middle housing requirement.
So hold on, and maybe Mr. Harala, why don't we end on this? Missing middle housing is not a TMC 13 term. It's more kind of an industry term. That means housing that is sort of in what would be a more mid-range of the market, as opposed to what we normally see with single-family detached developments, to make things a little bit more affordable, correct? So that's sort of how I see the definition of it. This isn't something that's defined in Tacoma Municipal Code, and it's not part of the regulatory framework that's applicable to this. It's just sort of the target market kind of that we're going for with this particular development more than anything, correct?
Correct.
Still under oath.
And if I can maybe add a little there, I will say that the PRD does point to essentially, if you want to use kind of common vernacular, missing middle or entry level or dense housing to increase the housing stock within the city. So it is part of the criteria for the PRD that we should favor projects that have more dense development that I think
More dense, more affordable. But not with a defined term of missing middle as a criteria.
No, not as such, but I wouldn't argue that missing middle is really kind of the Venn diagram that's heavily overlapping with what the code is asking for. So.
Yeah, sure.
Thank you. I'll touch now on kind of the civil side of the project. So of course the project proposes clear and grade the site within the developable 10+ acres as identified on our site map. The trees and vegetation within clearing limits will be removed during the construction. The critical area planning, so that we're going to preserve the critical areas by putting in, less fencing and identify those areas so they're outside of our clearing area. So those won't be touched during our clearing and grading activities. The proposed grading plan will meet what we call the preliminary grading plans identified as padded areas for the home. So when you'll see that, we'll cut in the roads and we'll pad out the lots to be able to bring in the utilities.
So pad there, just for people listening. Talking about a building pad, not something cushiony.
That's correct. It'll be a building pad. So basically you'll see where the buildings will be processed. There'll be a flat area for where the foundations are going to be laid. All grading activity will be completed utilizing best management practices for storm drainage, erosion control, etc. This is including and not limited to silt fence, engineering, construction entrance, soil stabilization, sediment control, and other best management practices as we deem necessary. We will also have a NPDES permit from the Department of Ecology, which is applied through Department of Washington State DOE. Utilities, Tacoma Water will serve the Plat with water. There's a project proposed to connect the existing water mains located in East D and East 80th Street. New fire hydrants are proposed to be installed along the internal public roadways to meet the city of Tacoma Fire Department standards. We have actively been in contact with Shelley Schaefer, Tacoma Water, for modeling and design requirements. Tacoma Water has been made aware of our desire to utilize fire sprinklers for the new structures and units.
So all the townhomes will be sprinkled.
That is the plan at this time. There are, yeah, that's the plan at this time. Sanitary sewer. The city of Tacoma will serve the Plat with sanitary sewer. The development proposes to connect to the existing sewer main within the easement on the west side of the proposed development. It's part of that easement and that trail system that joint use trail system. That's where the sewer is located along that west side.
Will each townhome have its own separate side sewer connection then to the main?
Yes. No sewers will be provided in any adjacent parcels at this time, as the parcel to the north is owned by Blue Ridge, and any properties to the west are located beyond the critical areas. The sanitaries, all buildings are proposed to be gravity systems with no pumps that are proposed at this time. Storm drainage. The entire project storm system will be designed to comply with the 2021 City of Tacoma Stormwater Management Manual. The developer and contractor will maintain stormwater best management practice during the entire construction process, including home building. Again, I want to reiterate, an NPDES permit will be applied for, and all conditions of that permit will be followed during the activity.
Or whatever stormwater manual is in place when you're coming in for permits, right?
That's correct.
You're not positing that this plat would vest you to stormwater regulations, are you?
Though we're currently under the 2021 City of Tacoma Storm.
Currently,
Yes.
right, but you're not positing that this plat would vest you to that, are you?
Well, at a certain point, it has to vest. I mean, once we
Well,
submit
sure.
at our site development phase, once we submit it for site development plan, it would vest, and we're anticipating it'll be the 2021.
If you have your full stormwater details on that, right?
Yes.
Because the reason I ask is because I'm not looking at this preliminary plat as having enough stormwater detail to vest you at this point. I don't think it does. That's why I ask if you're thinking it does.
Best to the standard.
Well, the site civil plans will vest you to this current standards.
So civil plans don't vest in Washington State. Things that vest are plats to what's on the plat, which is primarily your configuration, and then when you come in for building permits.
But at a certain point, the stormwater, and I know that this has been a sticky subject in the past, is that the stormwater is vested to the civil plan approval to the extent that
when you apply for your building permit,
to the extent that the civil construction's underway, as you vested that would vest you to the current manual, because there's too many.
Two things that vest in Washington State: perhaps to your configuration, and building permits to all of the development regulations that are in place when you apply for your building permit.
So are you suggesting that our stormwater manual, if we're under construction and we have an approved plans and we're working under a current NPDES permit, that the storm?
Well, PDES may treat it that way, but I'm telling you that there's nothing in Washington State law that says you vest at that point until you pull building permits.
Okay.
But for purposes of my question today, you're not positing that stormwater is vesting you to 2021 stormwater manuals by virtue of this plat.
Vest stormwater, they vest goes on.
They don't. Unless you've got your full stormwater detail on this plat that you're asking for approval.
Well,
unless you've got your stormwater system set in place in final detail on this plat, it does not vest it. And that's why I'm asking you the question, because I don't want you to assume otherwise.
No, I guess to answer your question, no, we're not assuming. We are designing the project currently to the 2021 City of
Right, because
Tacoma
that's what's in
stormwater.
place right now, and that's all you can do right now. I just don't want there to be confusion that you're thinking you're gonna be vested to that by virtue of this plat.
Right.
And it sounded like maybe you were, and that's why I brought it up, because unless you've got your final stormwater details on this preliminary plat, it doesn't vest it.
That's a recent change within the last few years. Pushed down by
Well,
DOE, correct?
The courts have gotten a whole lot clearer on what vests and what doesn't over the last 10 years. But that's because there was confusion over it for a long time. And we used to have what's unfortunately referred to as common law vesting in Washington state. But as of about 2015, the courts finally clarified that there is no common law vesting in Washington state. And the only two things that vest statutorily are your plat as to your configuration. And, I mean, you could submit a preliminary plat that had all your stormwater details on it, and that was your final stormwater plan, but that's not usually the case because you don't know yet. But if you don't, you're not vested to storm. You're vested to whatever the detail is in the plat.
All right, understood. So what as far as storm is being, we are proposing to discharge clean stormwater for wetland hydrology purposes to the wetland and at the wetland buffer and have the water disperse across the wetland buffer and drain into the wetland area.
And a lot of that's just maintaining the existing hydrology.
That is correct. We are going to be doing a hybrid of method 1 and method 2, and that's to get into the details of the stormwater management manual. There's a method 1 and method 2 analysis that needs to occur for the wetlands, and we will be doing a hybrid of that method. It's important to note that the roadway runoff will be directed to our on-site public storm pond, which will provide water quality treatment and also allow for release into the wetland after it's being detained at a metered rate. It's important to note there is a drainage ditch on site which accommodates runoff to the east. So there's the development occurred back in the, I don't know, 50s, 60s, 70s, whenever that occurred. And as part of that, drainage discharged from the east to the west onto our site. And our proposal is to take that and convey that into a swale that kind of runs down the center of the site and also along a kind of a natural trail that we're going to have in between the buildings. And that ultimately is a lot of the water which helped create and hydrate this wetland over the years. We're going to continue to maintain that existing corridor and flow path and not interrupt that at all. So basically we're taking that existing ditch and taking it and channeling it through the site and onto the edge of the wetland and letting it disperse the stormwater through.
And you said that channels stormwater from the parcels across the street to the east?
Yes.
Is there an existing easement for that?
No, there is not. It just dumps out onto the property. And so we will put that in. It'll probably be within a tract on our site, but it could be within an easement as well. So if you notice that it's running right down the center here.
That's where the two bolded lines are, kind of in the center of those?
Absolutely.
Okay,
yes.
Yeah, I see.
Power, dry utilities to come power serve the plat with power. We've already been in preliminary contacts with them about, power servicing and also relocation of power poles. It's still kind of up in the air whether or not the project will do natural gas. That's kind of a hot topic with the new energy code. So we'll see if these units, and that'll be determined at a later date. But to the point is, it is in the area if they so choose to utilize gas.
Lines in the streets at this
point. Roads. The proposed public roads on site are public. The proposed design is intended to meet City of Tacoma roadway standards. The proposed East C Street roadway would connect from East D at the north end of the building area to East C in the south end of the buildable area. The roadway design, as you mentioned earlier, is 28 feet wide with concrete curb gutter, and sidewalks are also proposed, which will be 6.5 feet wide.
So just to make sure, everything that's shown in the plat, the East 79th Street, Court B, East C Street, those are all going to be dedicated over to the city as public right-of-way areas when you're done with them.
Yes, absolutely.
And the alleyway too?
Yes.
Okay. It's not a problem for me. I just wanted to make sure I heard you.
No,
correctly.
I appreciate you clarifying that. So there's a 10-foot utility easement that will be located on both sides of the 42-foot right of way for power, gas, communication, etc. All roadway grades will be less than 10%, which is designed, it's the intent to meet the emergency vehicle needs, not to exceed. And the individual driveway locations will be shown on the approved civil design. There are some driveway locations shown on the current plans, but the final design will determine the exact location of those driveways. As you noted, a majority of the homes will be accessed from via alleyways, and those are also proposed to be public, and those are proposed at 20 feet wide with 16 feet of asphalt and 2-foot gravel shoulders.
And that's city standard, right?
Yes. Court B is proposed as a 24-foot wide with a curb and gutter. A 5-foot sidewalk and 6-foot planter strip is proposed on the west side of the road. The 10-foot utility easement is also provided on both sides of the 36-foot right of way. So we'll get into traffic calming a little bit. The proposed streets of EC and East 79th Street meet standards with traffic calming measures, bulb outs. Basically, they're traffic calming. Court B is modified alley sections. Lot 37 through 55 will all have rear alley access to the roadway, while lots 11 through 27 will be front loaded along this roadway. That makes sense. So I'll get into off-site roadways. Half-street sections are along the project frontage are proposed for East D Street and East 80th Street. This includes curb, gutter, 4.5-foot wide planter strip, a 5-foot sidewalk, and the necessary paving to match up to the existing paving. So I want to be very clear on what our proposal is, and this is typically what meets city standard, is that if the existing roadway that's out there and we're matching into it, we don't have to go all the way out to the center line of the street, that we can just put in the curb, gutter, and sidewalk, and then a portion of that paving, so it's not a full half width paving. So there are some areas where it'll be full half width, and then there'll be other areas that have kind of a match of the existing asphalt. A traffic analysis prepared by Heath and Associate. Aaron Van Aken is here today to discuss those, any related traffic issues. His report and analyze the traffic volume, site distance, and other potential impacts from traffic. Geotechnical analysis report was prepared by Earth Solutions Northwest, dated December 7th, 2021. Based on the results of the construction of the proposed reservoir is feasible from a geotechnical standpoint. Topsoil was encountered generally within the upper 18 inches. For stripping estimation, average topsoil thickness of about 8 inches can be assumed. So across the entire site, there's going to be some stripping of the native material. When I say across the entire site, across the entire developed site, I want to make sure I'm clear on that. In their opinion, the proposed residential structures can be constructed on conventional and continuous spread footing foundations bearing a competent native soils. Okay. Critical areas. And I will critical areas assessments was prepared by a wetland resources environmental consultant, dated May 23rd, 2024. Their report identifies several wetlands and buffers along the west side and a portion of the east side of the parcels within this development. There's, as mentioned earlier, there's also a presence of biodiversity area corridors also located along the west side of development. This area will remain undeveloped and set aside in a separate tract or tracts for preservation. Jeff Malahan is available to discuss the report and other wetland related issues if deemed necessary. Yes, I was gonna go in the cultural resource study, but that's gonna be a part of the appeal, so I'll leave that for them.
Okay.
Okay, schools, Tacoma School District, we've been in contact with them. It's Tacoma Public School District number 10. The appropriate school impact fees will be paid to the school district prior to the building permit issuance. Lighting on site, street lighting will be designed for New Broyde in accordance with City of Tacoma standards. The lights will be installed and operational prior to the occupancy of the first home. A licensed electrical lighting engineer will complete the design. Of course, the landscaping, detailed landscaping will be completed by a licensed landscape architect. This will include street trees, on-lot vegetation, and some open space replanting. The critical areas plantings will be provided by the wetland consultant and may also be included as part of this detailed landscape mitigation plan.
So when you say wetland plantings, is there vegetation in the wetlands that's going to be taken out?
It's buffer only. We're enhancing and
We're
clearing.
enhancing the buffer.
Yes.
Everything else is going to be left alone.
That's correct.
Okay.
Mailboxes, which is always important. Mailbox location will be approved by the U.S. Postmaster for the area prior to our placement of the mailboxes. So in other words, we go to the postmaster, they say, yes, this looks good. Go ahead and install the mailboxes in this location.
Presumably group boxes.
Yes,
than,
exactly.
front of every house.
Unfortunately, it takes sometimes months to get them to respond, but we're well aware of it, so we start that process early. So I guess in conclusion, as you've heard, staff has recommended approval of preliminary plat with conditions. While we're in general agreement with the staff report, there are a few issues, conditions we'd like clarified within the staff report and for you to consider or reconsider how they're worded. Evan Mann to my left will touch on those, and I will, of course, be assisting him with some of those as well. I think we've got a list of 7 or 8 conditions that we'd like to go through. And at this point, I think I will, unless you have questions of me, I will turn it over to Evan. But I do want to point out one last thing, kind of the process that we went through. I just kind of want to go give the history because I think it's important for everybody to understand that this is a project that takes years to kind of get through. So I want to just go quickly down this. So on January 19th, 2022, we had a pre-application meeting with the City of Tacoma. November 17th of 22, we had a preliminary plat. SEPA permits were submitted to the City of Tacoma, and then additional documents were provided shortly thereafter at January 17, 2023. On March 22nd, 2023, we received city comments. November 3rd of 2023, we responded to comments, to those city comments. In January 23rd and 26th of 24, we received additional city comments. And then on March 14th, we responded to those, and then the initial hearing date was postponed to work through some of the city comments. On June 5th, 2024, there was a response to comments submitted to the city. And then as part of that, there was tentative approval reached on that. So therefore the signs for the hearing were posted to the site on August 30th, 2024. And then September 24th, 2024, the DNS and the SEPA were issued. And of course, the staff report and recommendations were issued on October 3rd, 2024. And which brings us to hearing being held today. And then the MDNS shortly thereafter, hearing appeal will be heard next Thursday. And I do want to point out that in between all these dates, some of these dates looks like there's 3 or 4 months in between, but there was constant communication between consultants and city staff to resolve the issues that as we went through the preliminary plat process. So that concludes my presentation, unless you have questions, and I'll turn it over. I'll still be involved, of course, but I can turn it over to Mr. Mann, Evan Mann here to discuss the conditions he would like to have clarified.
Okay, let's just take one short break before we do that. I wanted to maybe change things up just slightly in the order.
Okay.
We are at 11:18. And I'm typing a message here to the folks on Zoom. What I have said is, people on Zoom wishing to testify, please add your name and contact information in the chat box now. So I want to see how many people we have wishing to testify. The reason I'm doing this is that if we hadn't had all of the hoo-ha this morning with the other room and the problems there, I think we probably would have made it through your testimony. Still had maybe a little bit of time for lunch before a lunch break for people to testify. That's not looking like the case now, depending on how many people we have wanting to testify. We have one in the room with us. We have two now online. I'm wondering maybe if it wouldn't make sense for us to break in your presentation, to hear the public comments, to see if we can get through those relatively close to the noon hour. And then those folks can either choose to come back after lunch or not, rather than making it essential that they come back after lunch because we haven't gotten to them. So,
It's acceptable by our team.
I guess.
well, that's fine.
If there's a vote,
whether
I'd
it is
vote
or
to
not, I
push
can still
through this.
impose
Yeah,
it
no,
on you
just-
if I decide to, but I'm seeing how many people we've got. All right, looks like we
I
have
guess it's just-
one,
I'm not opposed to that.
two, and that's great. I would have asked you anyway whether I decided to trample over you anyway. But one,
I think the longer it goes on, the more people will probably think not be able to stay on the line if they've allocated. some time.
Exactly,
It's
exactly.
already 3 hours into
Yeah.
the day.
yeah, and as much utility as there is in you all hearing the full presentation before you testify, I don't want you to have to stay around longer than you need to. So it looks like right now we've got sign up sheet again. We've got Stephen Jeffries here in the room, and online we have Jonathan Strivens, Carla Strivens, April Smith, and Andrea Haug. And so it looks like maybe we could probably get through those before the noon hour and then break for lunch, and then we'll come back. And then folks who are on, and whether you testify or not, if you want to come back after lunch or not, that's up to you, but you'll put your comments on the record. So I am going to do that. We're going to move to public comment at this point. I will note though, before we go into public comment, and I say this every hearing, I say it for my own procedural benefit, but also for all of you. If you have submitted a written comment, it's in the record now. Just like with everything that the city submitted, you don't have to say it again for it to be on the record. If it's in writing and you do choose to say it again, that doesn't give it any extra weight. It just doesn't. And if the first person who comments says exactly what the second person wanted to say, that doesn't give it any greater weight by having it said by two different people either. Because my role in this is to hear all the evidence and the public comment, and then weigh that against what the law says and what the facts show. And what do the facts show in alignment with the law? And that's what I base my decision on. There's nothing in the law that says if you get every single person from the entire neighborhood to come in and testify on it, that means I have to do it a certain way because there were that many people on it. It's not an exercise in direct democracy. So the greater number of votes who like it or don't like it or want trees saved and don't want to have the development happen because the trees will be gone, et cetera, it doesn't matter. There's no greater weight by that. Somebody who comments about saving trees, and if 1 million people comment about saving trees, those votes aren't tallied by their number. It's what do the facts say and how does that align with the law? That is my role. And our courts have said that in multiple occasions that, the popularity of a land use decision doesn't make any difference. Somebody's commented, am I trying to dissuade you from commenting? No, I'm not. I'm just telling you what the law says about this. So, an occasion, it sounds a little cynical, and, I'm probably a little bit of a cynical person by nature. But if you made your comments in writing and you come in here and you read that exact same thing into the microphone now, it doesn't give it any greater weight. That's what I'm saying. You can, and a lot of times people do, but here's the cynical part. all it really does is make the hearing longer if you've already made that comment in writing. I'm not trying to dissuade you. I'm going to give everybody their opportunity who wants to speak, but I'm just telling you so that because I do think people come into these hearings sometimes and thinking if we get the whole neighborhood in here, it's going to give it greater weight, and it doesn't. And sometimes people think I've said it in writing, but if I say it again here, it'll get greater weight. It doesn't. It doesn't. That's what the law says. So I'm not trying to dissuade you from commenting. And Susan, I didn't see you signed up anyway. Are you signing up now to speak? If you are, put your name and contact information in the chat box, please. With that said, we will start in the room with Mr. Stephen Jeffries. And if somebody could give him a seat at the table, just so he's a little bit closer to the mic.
Yeah. The mic.
And I
I've
will.
done this numerous times. I used to be a research scientist for Washington Fish and Wildlife for 40 years. So I worked on TAD.
So you've probably been a full-on witness many times.
Zoom since COVID.
Yeah. And I will also note just a couple other sort of procedural legal items. I don't swear in people who are giving public comment because probably, if I would be very conservatively low, 70% of what comes in as public comment is people's opinion and feelings about something as opposed to what would usually be considered hardcore evidence and comply with the Washington State Rules of Evidence. So I don't swear you in. If you are giving hardcore factual testimony and you think that's what you've got, you can't ask me to have you sworn in, but I don't typically do that. So with that said, oh, and two other things that I was going to state. I have the ability to cut things off if it starts to get overly repetitive. And one of the Washington State and federal rules of evidence is cumulative testimony can be objectionable. And when something's cumulative means it's been said over and over again and it's just starting to be repeated. And that goes back to that idea of it doesn't get greater weight the number of times you say it. So I'm shutting up now. Mr. Jeffries, the mic is yours.
Thank you. I live at 103 East 82nd, so that's the corner of 82nd and 8th Street. I've lived there for 40 years with my wife. We've raised our kids there. And I did, relative to submitting comments, it wasn't clear from the website how you submitted comments. I submitted an email to Larry. And I never got anything back from Larry acknowledging that he actually received my email. So it's confusing to me whether the comments that I made were actually incorporated.
If you submitted an email, Larry, I've got it.
Yeah. So, but we've watched the neighborhood change over 40 years. We appreciate growth, but the thing that we've seen is that the infrastructure from the city isn't keeping up with the growth in this neighborhood. You're gonna put 127 townhouses in a neighborhood.
119.
They said they could maybe up it from 100 up it. But anyway,
and I said
whatever, 127. So it's a big change from the 73 from Green Harbors to 127, whatever that number is. But they're going to generate about 1,000 vehicle trips out of that development per week, per their own estimate. Not 1,000, 981 is in their document. Vehicle trips per week. My question is these connections with C and these other streets, do the sidewalks just stop at the end of the development? Because there's no connectivity with sidewalks and streets to Larchmont, which is 4 blocks to the south of where the development is. So D and C all feed into Larchmont. If there's going to be kids in this community, where they're going to just come out of their sidewalks in the community and into the streets. So what's the infrastructure that connects this development with new sidewalks and new streets to the existing community that doesn't have sidewalks and streets. So there's going to be this oasis of a development in the middle of a community that doesn't have sidewalks and streets to go to the school that the kids are going to be walking on the streets, and they're going to generate 981 vehicle days trips per week out of their thing. So that's one question. How does this connect with other streets and that kind of connectivity? The other question is, are there going to be bus stops? Presumably there's going to be kids inside here in this development. Where are the bus stops? Are the bus stops going to go through the development? Those two things, and then the second one is the tree thing. That canopy that's in there, that 20-acre canopy, the city of Tacoma identifies it as one of the only remaining 20-acre canopy sites in the city of Tacoma that have trees above 120 foot of canopy. So they're going to cut down all that canopy. That 20 acres of oasis of a canopy is going to basically be removed. And my question is, how is it going to affect the heat index around the adjacent properties? They're going to cut all those trees down. How does it affect heat index? And the density issue, where on the east side of D, there's 2 to 3 houses per block. And on the west side of D Street with this development, it's going to become, the density has become 10 to 12 houses per block. So there's a density discrepancy putting this community into that number of houses into that community. And then another big difference between the original proposal for the plat was for Green Harbors, and you can see it on the aerial photograph of the site, the aerial photograph of the site, that the tree canopy was saved. This proposal is going to cut all those trees, clear cut all that canopy, and leave and add American elm as the tree along the. But it just seems like you're removing a tree canopy that exists as an oasis in the city of Tacoma and replacing it with American elm community that's not really, it's out of place. And I'll just end it at that.
That concludes your testimony?
Yep.
All right. And I will note, just because it did come up, you asked a couple of questions.
I did.
I'm the hearing examiner. I hear things. I don't usually answer them because I'm usually not the person to answer them, and it's usually not my role procedurally either. But when you pose those, my hope always is that the city's hearing that and the applicant's hearing that, and that as part of their remaining time, they still have time remaining on their initial presentation, but they also have the ability to do rebuttal, that they would maybe address those when they do that, because they're the ones who have the answers for it, not me. I do appreciate your testimony. Thank you for that. Thank you for hanging in with the difficulties this morning and for being here. And you're certainly welcome to come back and stay for the rest of it too.
I'll
but
just hang out till I listen to the other comments.
yeah, because like I said, it's a public hearing in the sense that anybody from the public can be here and listen and participate. And now we're in the other aspect of the extra public hearing and taking the testimony. So thank you for your testimony, and we will move to online now. And I did not put time limits on the public testimony. We have few enough people that I think we're probably okay with that. Mr. Jeffrey's testimony in terms of length of things was just about perfect. If we do get too long again, I can, exert controls on that if I need to, but I don't think we're going to need to. I recognize some of the other names we have on here, and they're seasoned testifiers, just like Mr. Jeffries is. So I think we're going to be all right. We have up first in the sign up on the chat, Jonathan Strivens. So I'm going to find you on the list and make sure you're cleared to unmute. And if you have video capability, I'd sure love for you to join us on the screen. So, Jonathan Strivens.
Good morning. Are you able to hear me?
I heard you say good morning. Can you hear me? It wasn't coming through terribly clearly, but if you can make sure you're close to your mic, go ahead and take it away because the mic is yours.
All right. I just have one quick comment that's procedural. In TMC 130607, it states that application for reclassification to a PRD district shall be made in accordance with the provisions of Chapter 1305, with a public hearing being conducted by the hearing examiner and final action being taken legislatively by the city council. And I interpret that to mean that the council will need to vote to approve the land use reclassification if this application makes it past the hearing examiner.
That's for an initial PRD. This is a major modification. So in most respects, it's the same because it is a major modification, but in some respects, it's a little bit different. That's why I asked the question at the outset, what Planning and Development Services position was on who makes the decision. Jonathan, you're still here. We lost you. You can stay on the screen. I'm not considering your testimony to be done, but I'm trying. The procedural question is mine to answer, whereas the substantive questions that Mr. Jeffries asked were not mine. So I'm trying to answer that. And the code to me isn't 100% crystal clear on that. And I'm the one who has to do the interpretation of the code ultimately on that. And I'm reserving ruling on that as to whether this will go back to council or whether I'll just be the one who decides. But we are having the public hearing today. So we're covered on that base in any event.
Right. I just wanted to bring to your attention that my interpretation would be that after your hearing, it would be appropriate for the council to hold a vote on that.
It's a valid point, and I will further construe and interpret the code as I'm required to do, and I'll make the decision on that once I've dug into it a little bit deeper.
All right. Thanks.
It's a valid point. Was that all you had?
Yes, sir.
Okay. Thank you for that. It is a very valid point. Thank you for your testimony today. The next person we have is Carla Strivens, and I'm going to make sure you're cleared. Come on screen with us. And you should be now, so if you can join us, that would be great.
Okay, can you hear me?
Yep.
Okay.
Fine.
Okay, I'd like to make a comment on, well, I wrote mine, so I'll just read it, because I wrote it so I wouldn't forget anything, but I'm saying that I do not have any confidence in this developer to do the mitigation correctly, since they already tore down the two houses that were on the preserve without getting a permit. I watched them do it. Insulation was flying everywhere. So they've already shown their disrespect for the land and the neighborhood. So there's really no reason for me to believe that they're suddenly going to respect the land or respect the people who live around it. So unless I misunderstood earlier, when the subject of the homes that were on there was brought up, I felt like they didn't say they already tore them down, unless I misunderstood what they said. So why would I suddenly believe that they're going to do everything they can and everything they're supposed to do as far as mitigation?
So that's a question again. I think a good bit of it's been directed to the applicant, and we'll see if they take the opportunity to address that. I will tell you this much from my standpoint of it, and possibly being involved in the enforcement of those conditions. If they don't follow the conditions or they're committing code violations on that property, relevant to, you know, anything, violating conditions of the plat, violating development conditions or whatever, and that gets brought to the city's attention, city code enforcement folks would first go out and investigate it. And if there is a violation, they would be issued a notice of violation. If they disagree with that notice of violation, it comes to my hearing room for a hearing. And if that were to happen and they were to come into my hearing room and I found that they violated conditions of the plat, of the MDNS, or just of the Tacoma Municipal Code, rest assured I will hold them accountable. I have
Okay.
very little tolerance for people who go into a situation saying, here's how it's going to be, and we're going to do all this stuff in order to get a permit, and then they violate those permit conditions. I have very little tolerance for that.
If I could add, the city was informed of this on June 29th, 2023. I do not know if the developer was required to go in and clean up any mess they made. I know they took out the building materials, but even the code enforcement officer in an email said that there was just insulation flying around. So I don't know if they had to clean that up or not.
I don't know either. I can't answer that for you. Maybe the applicant will address that. Maybe they will. It's a valid concern to raise. Is that everything you had?
From me, yes. Thank you.
Thank you very much for that. All right. So moving to the next person online. Let's see. We have April Smith. So let me make sure that you're able to join us. All right, Ms. Smith, you should be able to join us.
And I do want to say that you did miss Andrea.
Nope,
She
she's
was,
next.
oh, okay. She was
She's
showing
next
above
on.
me. So. I do want to talk about sidewalks and the roads in the area. As a disabled individual that lives near the park, I am really concerned that they are bringing in this many cars and people to the neighborhood and not bringing in very much infrastructure and having these the sidewalks end right at the property and not wanting to continue them to at least the major streets, like to 72nd, like through the park to 72nd and to 84th, so that, and like on C Street, so people such as myself and the kids can get to the bus stops safely. They say that it's a walkable neighborhood, but without this sidewalks, it is not walkable and it's very dangerous. And with the city aiming for Vision Zero, it's not going to be, I'm sorry, there's some noise in the background. It's not going to be, it's going to be going further away from Vision Zero with adding all these cars in. So please encourage more sidewalks instead of what they're proposing currently. Thank you.
Thank you for your testimony. I have some information that I'll give to all of the commenters about how that process works a little bit, just that I hope will be informative for you. And then maybe the applicant developer will address that a little bit, but I want to get to Ms. Haug first. I think we just have two more. We have Andrea Haug and then Suzanne. And then I'll put that information on just because I think it might be beneficial. So Ms. Haug, I hope I'm pronouncing that right.
Hello. Thank you so much, Mr. Hearing Examiner, for the opportunity to speak. And also thank you for acknowledging and noticing how time can be crunchy. And even though it wasn't anybody's fault, technology, right?
Yeah.
So yeah, let me gather my thoughts. Let me turn my video on. I'm sitting in the car. I'm sorry. Because I'm heading off to the next thing. Again, my name is Andrea Hogue. I'm the chair for the South End Neighborhood Council. We are a community-led volunteer advocacy group. And I do know that April Smith touched on sidewalks, and we didn't want to be too redundant, but I do want to encourage sidewalks to continue in front of Charlotte's Blueberry Park down to 72nd for connectivity. The bigger picture is we live in a school district that's a choice school district. Students will be leaving the development to go to specialty schools such as Sammy and Point Defiance, Idea High School, Soda downtown. So safe access for these students to sidewalks to reach transit, to use their ORCA cards, which are provided to them to get to school, is imperative. Also, the Neighborhood Council is currently working in cooperation with Metro Parks to install a food forest. We procured a $171,000 plus grant through the Department of Natural Resources, and the food forest itself would need to be accessible to residents coming from that direction. And given that we're living in a time where there's inflation and such, we as community members are trying to offset the cost of things, and being an HOA community in a low equity area, it's still going to be a little bit much for our community and residents here to experience homeownership there and pay HOA dues. So I believe that the food forest would be beneficial to residents to help offset the cost so that it would enable them to be able to pay their HOA dues. So accessibility. We just did a walking tour in that area. And really, if you put someone in a wheelchair and start pushing them around, you'll see the lay of the land a little bit differently. And again, with the choice schools, the children really need to have access to all bus routes. Thank you so much for your time. That's all I have.
Thank you for your testimony today. Appreciate it. All right, and then Suzanne, we've got you on, so let me get you cleared. You should be able to unmute now, and if you have video capability, joining us on screen would be great.
Hi. I have a few questions. So, number one is is the area around where you're trying to build a development. So I lived on East F Street, which is one street up from East D, same as East D, trying to turn out onto 72nd. That's a long wait, and sometimes it's even blocked up past East D Street because of the vehicle stopped at the McKinley stoplight or the vehicle stopped at the 72nd Pacific stoplight. So is there any update to, are there going to be any new traffic lights, or are we just going to have to, like the citizens who already live there, with adding, I think you said 117 new residents, which is potentially over 300 driving people if you have a spouse or children? Are there going to be any updates to how the streetlights are, how those streets are routed? Or are we now going to have to maybe wait like 20 minutes to turn out onto the street because it's already busy as it is with the people in our neighborhood? And another question is, the speed limit is 20 miles per hour on Tacoma streets now. We already have people speeding down the street, speeding down East F Street, going over probably 30 miles per hour. Nothing's done about it. Is there going to be anything that's done to enforce that? There are children living there. There are pets there. Mostly my concern is the children's safety. Is there going to be anything done in that retrospect? Or are you just trying to add like 300 plus people to this area and there's nothing going to be done streetwise for the rest of the neighborhood? Like, we're just going to have to pick up the slack, have cars stacked down our street waiting to turn on to 72nd or McKinley. or have cars like racing down the street, because unfortunately some people don't obey the speed limits.
Those are questions that I can't answer for you, but city staff may have some rebuttal on that when we get to that part of things. Is that the end of your testimony then today?
Yes, I'd also like to add that I don't think you're doing anything for this neighborhood. I think you're just trying to put money in your own pockets, but you know, that's what a lot of developers do. That's the end of my testimony.
Thank you for that today. Thank you for sticking around. It certainly wasn't my intention to try to dissuade anyone from testifying, so I'm glad you stayed with us. That does look like the end of the list, though. And before we go back to the applicant or wherever we're going to head here at this point,
I asked a question about the material that was presented for the commenters that aren't in here. How did we get access to the PowerPoint stuff, the material that you're discussing here? You're going to some files. How do the commenters, the people of the public, get access
for all the hearing exhibits?
Yeah. The PowerPoint that the city gave.
Usually you have to ask for it. What I will do is I'll just make a note. When I issue the decisions for this whole compendium of permits and on the MDNS appeal, fortunately, as of about 8 months ago, wasn't it? We got the city to post those online for us, so they'll be available on our page. I will try to put a link. I'll put a link there too to the exhibits as well.
I mean, I think for the general public, just a comment in general, for the public to access, you guys live this stuff, right? So you know all the links, you know how to maneuver this, but for the general
well, I've
public,
got your email address. We'll send you the link in your email.
Perfect.
Okay. And I wanted to add too, for anybody who's still online, public commenters, like I mentioned, when you ask questions as part of your public comment, my hope always is that either the city or the applicant will address that in rebuttal. Sometimes they do, sometimes they don't. Sometimes if they don't, and I want to know the answer, I will ask the question and make them address it. And we'll see if that happens or not. But if you don't want to stay through the rest of the hearing, when we are done with this one, I am going to post the video to the hearing examiner's website. And if you want to check it out there, you can. I will try to send out an email to everybody who gave me an email address today when that is available, so that you can see if your questions did get addressed or answered. Even if you don't want to hang around for the rest of the hearing, you can go and check it out on the video. All right. And with that said, we are almost to noon. It makes sense to me to just go ahead and break for lunch. Normally we break at noon and we come back at 1:30, but we're breaking a little bit early. So what I'd like to do is we'll break and we'll come back at 1:15. I suppose you can hang out here in the conference room if you want, or you can go out and then come back. If you don't have a guest badge, you'll need to get a guest badge to come back up to the 7th floor, or you could have security call. I'll come down and get you, I guess. But rather than doing that one at a time, well, I'll tell security we're going to have people coming back. And if they're asking to come to the hearing examiner's conference room to give you a guest badge. And we'll reconvene at 1:15 instead of 1:30. All right, at that point, we'll pick up in the applicant's presentation. And when the applicant is done at that point, we'll see if there is rebuttal by way of answering questions from the city. And I don't know, for the applicant's rebuttal, you can just take care of that as part of the rest of your presentation, if you're so inclined. The last thing that I will add is there were a lot of questions and concerns that came up in public comment about improvements in and around the area, street improvements and these kinds of things. I wanted to throw out for the people who are still listening, and you'll hear it if you come back to the video, I guess, later. The city can impose conditions on approval of a plat or on approval of a PRD or a major modification to a PRD. They can impose conditions on a critical areas minor development permit. But the ability to impose those conditions is not unlimited. It's not infinite. We have a good body of jurisprudence from the U.S. State Supreme Court on down on the constitutionality and the constitutional parameters of requiring those conditions. And so if you want to really just twist your mind into knots, Google Nolan and Dolan. And then the next case that came after that was the Kuntz case. And there's another one that's recent. The case is escaping my mind now. These are all U.S. Supreme Court cases. There's a fair amount of Washington case law implementing that, but those principles have been enacted into our code, and they're the concepts of nexus and proportionality. So before the city can require a condition for any type of development when it's a conditional permit that conditions can be imposed on, not all are. Some are what's called a ministerial permit that just, if you meet the criteria, boom, you're given the permit and you can't condition it like a building permit. There has to be a nexus with the proposed development and that condition. So for example, you know, the proposed development is going to create X number of additional trips, like was referenced by one of the commenters today. And so therefore, we are requiring, you know, the half street improvements were mentioned already during the applicant's presentation. That there's a nexus there with the traffic impact analysis that was done, that was required by the city, and those improvements that are being required or requested, may be required once it gets into my decision, if it does, by the city. So there's got to be some connection with that. You can't just say, well, it'd be nice if we had this thing down over here too, so why don't we make the developer pay for that? Is there a nexus? If there's not, you can't require it. And then with that nexus, the exaction of the conditions has to be proportional to the development side. This is a pretty substantial development, so that scale of proportionality goes up. But for example, if you had someone come in just for a permit for a single family house and the city piled on all kinds of development conditions on that, there'd be a point where proportionality is violated by that, and it becomes unconstitutional to exact that level of condition. And so that's what the city is operating under. That's what I operate under when I review the proposed conditions from the city. And in the MTNS appeal, the developer is challenging two of those conditions, and nexus and proportionality, and the Nolan and Dolan and Kuntz and the other cases. Those are the backdrop for that, with what can be and can't be required as a condition. So it's not just whether it's a good idea, it has to have a nexus to the development, and then it has to be proportional to that development. All right, so with that said, we're going to break for lunch. Please be back here on Zoom or in the conference room here if you're choosing to come back here at 1:15.
Also leave bags in the conference room.
It'll
here
be safer. Nobody could get in this door except my staff and very limited number of city people.
Perfect. Thank you.
All right, thank you for being here, and we'll see you back at 1:15 if you're back. And if you needed to be back, please do come back. The recording will be paused. Andrea Myers, would you give me an okay that you're hearing us out there, please, if you would?
Yes, I can hear you.
Okay, I'm going to assume that means for everyone. City staff, just give me a thumbs up if you would on the screen if you're hearing me. All right, good. It looks like we're rolling just fine then. So we broke for lunch. We're back now at 1:15. For purposes of just record on the audio identification, this is primarily a public hearing on the preserve plat that has a whole bunch of other things tacked onto it: critical areas minor development permit, site plan, major modification to PRD, And I'm just going to repeat here, anybody who is not speaking or city staff, I'm going to keep your camera off to preserve bandwidth. It'd be a real plus for me if after I turn you off that you don't keep turning it back on unless you're going to be called on to speak. So we are back with that. We heard from the city as the initial presenter in the morning. We started hearing from the applicant, and then because I thought we could probably get public comment done prior to breaking for lunch, we took that out of order somewhat, and we did get it done before lunch, and we've had lunch now, so everybody is fed and groggy now. And we will go back to the applicant's presentation at this point. Mr. Deaver, I think you were done with your main presentation, and that's why we broke at that point. Is that correct?
Yes, sir. I'm going to turn it over to Evan Mann now.
All right. So
I can swear in, but I would add to kind of round out the testimony before we go to rebuttal on public comment. We want to hear from, it'd be nice if we could have our wetland biologist and our traffic engineer.
And that's up to you.
Some testimony.
Like I said, sometimes I make people testify who the party wasn't particularly planning to testify. The hearing examiner rules allow me to say, I want to hear from this person, or I want you to give me additional information on this, that, or the other thing. But I don't usually do that. I usually let you present the way you want to present. And my apologies for kind of breaking you guys off at that point. But hearing examiner rules also allow me to take the public comment before anybody presents, which I've never done, although I thought about it this time. But again, like I stated this morning, it seems to make sense to me to have the people who are here to comment, hear what really has gone on and what's happened. And so ideally, I like them to hear the whole presentation before we do that. But I didn't want them to have to come back after lunch if they didn't want to. So that's why we did it that way. My apologies again for breaking up the presentation. But if we were to you now, Mr. Mann,
yeah,
that will be just fine. And like I said this morning, most of the times in a hearing like this, rebuttal is more geared to answer the questions that come up in public comment. I suppose the city could have rebuttal from you because they went before you and to rebut things that you bring up. And that's perfectly fine. We'll still give you the opportunity for that. And we may need to hear from some of the city staff who are on with us in Zoom when we get to that point. I may want to hear a little bit more from them. Or you may want to call some of them, Mr. Harala, and that will be fine. As far as the applicant goes, so anything that you would have had for rebuttal of what the city has said or what came up in public comment, go ahead and just feel free to include that as part of your, now resumed case in chief.
Perfect. Then to start, we'll just round out again. Craig did a great job of summarizing.
Let me get you sworn in first.
Would it help to swear all of us all at the same time, or one at a time? Your call.
I don't like group swearing necessarily. I think I've done it once. We'll just swear you in as you come on. So if you'd raise your right hand, please. You swear and affirm that the testimony you're about to give as part of this proceeding today will be the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes.
Just a tad, upward just a tad bit, so we've got you in full frame there. Go ahead.
So yeah, I'm honestly I'm just swearing in, but want to pass the torch over to Jeff Malahan to speak more directly. Again, Craig did a great job of summarizing the overall project. He's been involved from the beginning, working with the city and us to get this to where we're at. But there are some minor or some elements of the project that have an outsized importance, and one of those being the 28-acre site has significant wetlands. We brought our wetland biologist Jeff Malahan to be able to speak to kind of the process of how we got to where we're at and kind of establish some record there. So if we can pass it to Jeff, and then we'll go from there.
And if we need to come back to you, that's fine. You'll still be under oath. So if we want to come back to that, that's fine. Let's see. I'm just looking for witness list and I have to spell your name.
Jeff.
Yeah, Jeff that way too. So it's Mallahan, right?
Correct.
And Jeff, the same as my Jeff, Jeff. Although you're probably a Jeffrey and you shorten it, right?
That's true.
I am just Jeff.
Oh, wow.
Parents name me
with two F's, not three.
Just two. Yeah, parents name me the diminutive. So I have people, wanting to expand it all the time. And nope. Back down. All right, so let me swear you in. Swear and affirm the testimony you're about to give as part of this proceeding today will be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, tell me what I need to know.
Yeah. So thanks, Evan, for presenting, and the city, and also Craig for kind of giving a good summary of kind of what we're proposing here in the history of the project. My role kind of came on with Evan, kind of reaching out to try to address some comments that came in regarding amphibian use in the wetlands, and then wetland protection, and preservation of biodiversity corridors and those areas that are on the property. And so my kind of role in the project as an expert in designing mitigation and kind of assessing critical areas was to work with the city and the existing previous reports that were provided by other consultants to kind of review what was done and then create. Go ahead. You have a question?
No, finish that out, but
Okay.
then give me a pause for just
Yeah,
a moment,
absolutely.
if you would.
And then to create a response to the existing comments so that we can get kind of to here was the goal. And so I worked, go ahead if you have a question. Sorry.
Go ahead.
Yeah, I worked with Carla and Mika specifically, and I appreciate their help on kind of guiding us to, come up with a plan that met the city code, to get some clarification sussed out from the previous mitigation plan, and kind of expand upon that to really create a mitigation plan that resulted in a net benefit to the site. And I think that that's kind of an important piece of this, is that, what was previously proposed didn't have all of the details to kind of, suss out those specifics in providing equitable mitigation and no net loss of habitat function. And in the end is resulting in an increase overall of functions and values for the wetlands, which is pretty cool.
Here's where I'm
So,
gonna take that pause.
Sure.
If the applicant had their attorney here, the attorney would have started by asking you to give me a little bit, you're essentially the applicant's wetlands expert.
Yes.
So tell me why you qualify in that position, so
Sure.
I got that on the record.
Sure. Yeah, I
please.
should have started with that. Yeah, I'm Jeff Mallahan, senior wetland biologist and fish ecologist for Wetland Resources Incorporated, consulting firm in Everett. I've been working in private consulting for almost 15 years, and previously as a fish biologist for National Marine Fisheries Service. Worked as a restoration specialist for a couple nonprofits and for Snohomish County Surface Water Management Program and the Washington Conservation Corps. So yeah, my experience is broad in the sense of disciplines, but I focus on habitat restoration and ecology for my entire career. Have a bachelor's in science from Western Washington University Ecology and Environment. So yeah, I've worked with Evan on and Copper Ridge and Kirk and a number of projects, and so they brought me on as kind of helping get them across the finish line, which is my expertise. So yeah, that is the basis of.
Thank you for that.
Yeah. So yeah, and I think, and we can do this in a couple different ways, but I kind of wanted to jump into the approach and then responding to some of the public comments, if that's appropriate, Mr. Examiner, to do that now as well.
That's fine.
Okay. Yeah. So part of the goal was to address Carla's comments and also the city's comments about making sure that to verify and confirm sensitive species and habitat types that are on the property were protected, and that the stormwater plan that is designed continues to protect those species and maintain wetland hydrology, which was previously testified to. And so that was the goal of the creation of my report, and chiefly utilizing the previous report. As I was not the author of that report, I cannot repeat their information without referencing it. And so my approach for creating a report was detailing the previous report, and that was as a request of the city to make it clear, and also for the examiner's review to make it clear, so we're not referencing in multiple reports back and forth and not creating multiple addendums to the original report. So, and to do that succinctly, we created a standalone document. And I think that was well presented, and we kind of agreed to that with the city to prepare it that way. And so we did do an analysis of the site in coordination with Fish and Wildlife, assessed for amphibian use in Wetland D specifically, did find amphibians there, and then as a result are in the works of designing a stormwater plan that continues to protect the breeding habitat when they're breeding on site. And so as far as other protected species that are mapped on the project, there's kind of a misnomer of the data set for the public, and I appreciate the public's kind of interest in protecting sensitive species on the property, and there are mapped sensitive species on the property. However, those are data sets that are controlled by Fish and Wildlife and are not public information. And that is specifically to protect those species from being disrupted, those habitat types from being disrupted. And so when certain things are mapped on the property, they're often mapped as masked data, which refers to township level assessment. We're talking township like 36 square mile assessment. So if they're in those polygons within the site, if the site falls within that data set, it's shown as having those species with the potential to be there. So we consulted with DFW to confirm if there were not other sensitive species on the site, and their results was that there were not. So western pond turtles, breeding habitat for bats and other things like that are not on the site. And as such, large trees and concentrations of trees are important for movement of wildlife and protection of wildlife, on a long-term basis. And it's true, as the public kind of noted, that we do have a nice forest here that's connected to, other areas of open space. And so I think that as the city testified that, the nomer of the preserve is true and factual, because we are preserving 18 acres of the site, including, wetlands, their buffers. But then part of that is also, maintaining this relatively small development envelope of 10 acres. And so we're not losing a ton of canopy in the totality of the site if we're considering the rest of the property. And I think that's a pretty cool approach that's not often done. I think normally applicants want to try to get away with as much as they can, and you could have approached this a little bit differently and have more of intense development. And added to that is our proposal to provide pretty significant restoration and mitigation plan to maintain a corridor for wildlife movement, but also for enhancement. We're proposing to enhance the totality of the site outside of the development envelope, which is not normally done. We're nearly a 10-to-1 ratio for the city's required enhancement requirements for buffer impacts and also for biodiversity area impacts. So we're well over the ratio that the city would be required to provide. We're doing nearly 5.5 acres of enhancement. And I don't know if a lot of the public has been to the property. It sounds like they have. Outside of the maintained areas that is the Blueberry Park or the fields and stuff, there's a lot of invasive species. So there's a lot of blackberry, there's a lot of ivy, there's a lot of invasive species that limit diversity in the forest there. Even on site, if you were to walk the site, there's been a lot of damage from the public and from other use on the property that resulted in damage. And so the goal of the enhancement plan is to recognize that these areas are sensitive and to reestablish a primary forest component in the buffers all the way around the site, and to condition that on a maintenance and monitoring plan that would have to be approved by the city. The monitoring plan that we came up with was a direct reflection of the original plan, which again is very stringent. They have, for example, a 2-year requirement for 100% survival of planted material. That's pretty much never required. But we're doing that as in concert with the kind of negotiation with Carla and the city to try to come up with something that is reasonable and results in a net gain to the site. And my goal as like an environmental consultant is trying to balance the development need and then the reaction to the environment. And in this case, there's no, I tend to say this a lot, and maybe this isn't really relevant, but there's no mechanism for the city to force enhancement, restoration, removal of invasive species on private property. It doesn't exist. Wish it did. It doesn't really exist outside of, noxious weed control boards and those types of things. And so with this development plan, we do have a mechanism. Well, sure, exactly. That's what I'm saying. So in doing that, we can condition some of these things. So I think that's important to recognize. And yeah, we are proposing, so with the loss of a significant stand of trees as a result of the mitigation plan, they're proposing over nearly 3,000 trees to be planted, which is a lot. Sorry about that, Evan, but it's a lot. And then there's also other habitat features that is a condition of the mitigation plan as well.
So let me just interject with a question.
Sure.
So limiting development to the 10-acre area there, and you two both still under oath. You might be the better ones to answer this question, but because it's just come up, I want to ask it while we're on it. That 10-acre area, if I understood correctly, is going to be basically cleared and graded and then developed, but then there's going to be a lot of landscaping, trees coming back. So you mentioned street trees are going to be planted. That's great. Street trees is one of the list of things that you look at, adequate provisions being made for these things as part of the plat. They're going to be street trees planted. I presume there are going to be other trees and things that are going to be planted back into the 10 acres. And I think that's what you were just addressing. So I want to ask, is your landscaping plan and the plan for street trees and all of that far enough along to where you could tell me what percentage of canopy cover the 10 acres will have once things get established? And if you don't know, that's fine. But if you can't answer that question, it does factor into, things I look at in the decision.
I'll speak to that. We don't have an exact estimate. We anticipate that it will likely be close to the percentage that the city has requested in condition number 5. But we would note that again, out of 28 acres, over 60% is being retained in perpetuity as canopy.
Right,
So
and I understand that the city council's goal of 30% canopy cover. You meet that probably on the whole of the subject property just by everything that's going to be retained.
Right.
But I was specifically trying to look at the area to be developed. And it sounds like you said that you think once everything's established, that it'll be close to 30% canopy cover with the replantings.
No, on the development portion of the site, no. I mean, that's the specific area where we're doing townhomes. We think we'll be close to 10%. 10%, but certainly, in the way of overall canopy, we meet the city's goal of 30% and exceed it by significant margins. As a project wide.
Okay.
Yeah,
back to you.
and to that point, what I'm referring to is the enhancement outside of the development area. So we are introducing nearly 3,000 additional trees in areas that are dominated by invasive species currently.
Okay.
So that's additional canopy that will be established in areas that are dominated by mostly ivy, Himalayan blackberry, and open fields.
And that's in the undeveloped area.
That is the undeveloped area. So then again, reconnecting the corridor, maintaining the corridor that exists, and increasing overall biodiversity areas that would be regulated in the city and protected with the plan. The other thing that this project is doing that is above and beyond the code is providing a wider corridor than is normally required. So you're required a certain distance of corridor, 300 feet. We're providing 300 feet at the minimum width and up to, I think it's 600 feet at the widest, nearly 600 feet at the widest. So you're maintaining the corridor that is there, and then in addition, providing additional width. So again, the mitigation plan's goal was to kind of enumerate the impacts that were previously described and just get a little more detail in there so that we actually have a quantitative assessment of what's being provided area by area. So yeah, that is the end of my testimony at this point, unless there are any other questions. I want to make sure I hit on the other comments. Sounds like good. As far as street tree species, I mean, this isn't really something that I can speak to very specifically, but street tree species selection is based on city code. And that is a function of root growth and canopy, crown cover, and to not disturb utilities and other things. And so, yeah, I would love native species to be in the city, but they would kind of dominate, destroy things. So they tend to use cultivars of other species.
Plant big giant maples in a
in a planter box that's not
wide,
really
like
going to work.
at my former location, I lived in northeast Tacoma because they were busting the
you're gonna lose
sidewalks
the
up
sidewalk in
everywhere,
about
and
3 years.
Roots were getting into the side sewers.
Yeah, exactly.
Right. Are there cross-examination questions for this witness from the city?
Not at this time.
This is the only time,
Well,
unless he comes back for more rebuttal. This is your shot.
We don't, in conversation with staff, we don't have any questions.
Okay. All right. Who's next?
So our next would be Aaron, and you're welcome to just kind
Swap me
of
there.
keep it pretty simple with kind of what your findings were in your traffic impact analysis. So, and obviously, it sounds like we'd love to hear kind of your credentials first. So. Sure. But first, you got to get sworn in.
You do. Could you raise your right hand, please? You swear and affirm the testimony you're about to give as part of this proceeding today will be the truth, whole truth, and nothing but the truth under penalty of perjury.
I do.
Go ahead.
So my name is Aaron Van Aken, and I'm a principal engineer with Heath and Associates. We've been in business for over 30 years, and I'm a licensed engineer with about 12 years of experience. I am the author of the traffic impact analysis that we conducted on the preserve. A traffic impact analysis is basically a detailed study that assesses the potential impact of a proposed development that would have on the surrounding network. It evaluates traffic conditions existing and future, both with and without the development. So the study that we did for the preserve was scoped out with the city staff, and it entailed evaluation of 11 intersections around the site proximity. We found that all locations with the project in place would meet the city mobility standards. One of the public comments made reference to high delays from D Street trying to go onto Canyon Road. That was one of the intersections that we evaluated. And
72nd.
Oh, sorry, 72nd. Thank you.
It's bad at Canyon Road too.
Yeah.
That's probably on her commuting route. She can tell you, but
Yes.
I think we were at 72nd.
Yeah. So the grading system in this in traffic engineering is what's called level of service, and it evaluates it just like a report card, A through F. The city standard is generally D, so you have to have an intersection that functions during the peak time, D or better. And with the project in place 6 years from now, we are estimating that the delays at that intersection would be D, which meets city standards.
And what is it now, did you say?
I believe it's C now.
So it'll fall, but not below the city's.
Correct.
Well, the city's standard that said, I won't make any commentary.
Correct. And the volumes on D Street are not high enough that would warrant further improvements such as a traffic signal. There's minimum volumes that you need to warrant putting in a device like that.
And the city's traffic engineering staff concurred with that?
Yes. The other one, traffic calming, there was some public comments about speeding. That may be an existing issue. It's not something that we monitored or was required to be evaluated. However, all the roads in the area are relatively narrow. They have some on-street parking in areas and short block segments. Those all act as traffic calming in themselves. So if speeding is an issue, that oftentimes can come down to enforcement. All the local roads in the area carry relatively low volumes, and the site is being developed with traffic calming devices such as curb bulb outs at almost all the intersections, and potential other traffic calming devices on nearby public roads. Non-motorists, there's comments about pedestrian connectivity. The project is putting in substantial improvements with over 1,100 feet of public sidewalk on D Street, another around 700 feet on East 80th Street, among all sidewalks and shared use paths that are internal to the site. They're also going to be putting in ADA directional curb ramps at several intersections along 80th and along D Street that would further enhance multimodal transport in the area. And with these walking routes to school, that will, if they are deemed unsafe, then the school district could put in bus stops with coordination with the applicant at locations that would be deemed safe. And I think that concludes my summary, and I believe I touched on most of the public comments.
a cross-examination from the city for this witness.
Yes, I have just a couple quick questions. Thanks, Mr. Hearing's examiner. So on this, I just would ask you, can you go into just a little bit more detail on the C to D? You mentioned a 6-year period. Is this just from the project and what you looked at, or are you looking at sort of broader conditions in the area and
Okay. So currently, when we conducted the report back in 2022, the intersection of East D and 72nd was operating at a high level service C. And then we forecast 6 years into the future where we build in the background growth rates to account for miscellaneous development in the area. Without the project and the future conditions, it's projected to degrade to D without the project, and would maintain a D with the project. It would add about an average of 4 to 5 seconds of delay for a driver trying to enter onto 72nd.
yeah, so the project itself, I just want to get on the record that the impact is not anticipated to be great in terms of the conditions are expected to degrade sort of no matter what happens on this site.
Correct. And D is still an acceptable level of service.
In Tacoma anyway.
Yeah.
The other question I have is just kind of, since you mentioned it, brought it up, are you guys planning on, are you willing to, as we move forward? And if it's not for you, I appreciate that, but with Tacoma Public Schools on maybe, citing a bus stop or like trying to anticipate, if there's anything that could be done. I mean, we don't have that as a city condition, I don't believe. We will be providing some rebuttal, and I'll have some of our folks maybe speak to this. They're listening, so this may come up.
Well, and I wanted to ask about that too. It came up in public comment about provision of bus stops, and I'd love to hear about that, whether there's been analysis done on that, because that is one of the TMC 1304-100 D1. Actually, it's E1 now. I think this is an old reference in the staff report, but that is one of the things that when I'm the decision maker, one of the directors deciding on these things, one of the things that you're supposed to evaluate for adequate provision of in order to approve the preliminary plat is bus stops. And as Mr. Deaver knows, we had a hearing back in the end of August. The development that was under review in that one for the plat, they were actually providing a bus stop across this main arterial street that led into the subdivision. And that was great, but I haven't heard anything about bus stops on this one, about providing them or why they were determined that they didn't need to be provided and they were already adequate for this location. I'd love to hear about that because that's one of the things I have to analyze.
So we did analyze transit bus stops and the walkability to get to those as well. That was in our,
right. We did talk about that.
And we also looked at the school. We did speak with the school. They did not bring up bus stop locations, but if it becomes apparent that a bus stop is needed, we do have a place to put it on or near the site. So we're not opposed to providing that bus stop. But what we did hear from the school is that, as you heard in testimony from the public, it is a choice area. So it is difficult to know where everybody's going to go to school. So a lot of them, the reason transit was important is a lot of those school age children are going to use that transit services available to get to the appropriate schools.
Okay, that helps. That reframing context helps. And I suppose ultimately you would need the school district's buy-in, I guess, for where something is going to be located. Because I know the public commenter asked about that and said, we don't know whether school buses are just going to come on the periphery, where they're going to come internal, all that kind of thing. Because if the ultimate bus route that the district decides on having here, since the roads proposed in the plat are going to be public streets, they could come in and do a loop around the preserve and pick up kids in there, I suppose. But the school district ultimately, I guess, would determine that, correct?
Yes, that's been our experience, is the school district determined that. And most of the time they do not like to go internal to the plat. I have seen them do it, but most of the time they would probably be along East D Street there. So
they do it. I've seen it. Okay. All right.
I had no further questions.
Okay. I had to think there for a second. We're in the middle of cross and then got off on another one of my tangents. So
So
anything you want to add additional based on the cross-examination questions from Mr. Harala? My bust up tangent.
No, not this time.
Okay.
thanks, Aaron. So I've got a kind of list of things that I'd like to speak to. This is Evan Mann with the Copper Ridge.
Okay, we'll come back to you. You're still under oath, so go ahead.
Okay. So I feel like for the most part, the rebuttal to public comment has taken place. I did want to speak briefly about the existing structures that were on the site. So with regard to the structures, they were in a state of construction. They were not complete. So technically, there was no
one that was, wasn't there?
It had never been certificate of occupancy completed. So technically,
was a demo.
yeah. So technically, the structures were construction materials because they hadn't been formally approved for certificate of occupancy. So we ran into a problem at the time with the city of getting a demo permit for what doesn't exist. Effectively, there was no building. There was no formal building on the site. There had been no formal established completion of these buildings. So they were construction materials. And the problem was we had gone the rounds with the city to try to, we'll pull the demo permits, we'll get this going. But at the same time, and we've heard it a little bit, the invasive species on the site wasn't limited to plants. We've had significant problems with vagrant homeless use and drug use on this property. And those three construction sites were attracting significant attention from that population. So we were having regular calls from fire and from police to go out there and they were going out there to put out fires, to stop shootings, to stop prostitution in these buildings. So they were a very imminent public nuisance. So in our effort to be responsive to like public, risk or problem, we took those buildings down. Again, we got into basically a back and forth. When we talked about taking them down, it was get a demolition permit, but it couldn't get a demolition permit because there also aren't buildings. We got into this long, drawn out back and forth. At the end of it, we're not opposed to getting a demo permit to back permit what was done. That's not that. So that's something we are working on with the city. But effectively, there was an imminent concern of being pushed by both the fire and the police and the community. I don't recognize any of the names of the public commenters today, but many of the neighbors, and I have their names, and we have a long record with them. Many of the neighbors were regularly in contact with us about this issue, and we've been responsive. We've been out there to remove homeless camps. We've been out there to remove trash, and we've been very responsive to those concerns because that has been the imminent concern currently. And so again, the structures were removed. If a demo permit after the fact is necessary, we are not opposed to that. We can work through that. But there was an imminent concern and danger that we were trying to be responsive to for both police and fire at that time. So that explains kind of the history of that. I'm happy to answer questions about that. Just if there's any that specific item, I have a handful of other things to talk to. But before we move on, if that's something we want to.
Well, let's save cross till the end.
Okay.
I butt in with questions when I feel like I need to, but I don't feel like I need to on
Okay.
that one. So let's just keep going.
Okay. So I believe it was one of the commenters brought up the topic of our appeal for the MDNS, which is an off-site sidewalk extension that I'll refer to Exhibit C3. If we can, I'd like to look at sheet PP1.
Actually, have to give me a second here.
Yep, no
because
problem.
There's a vast expanse between C2 and all of its subparts. And
Yeah, there's a lot of
C3
them there.
coming up. And if I collapse them all down, they all go away. Oh, there it is. C3.
C3 PP1 is the basically the cover
PP1,
sheet.
Okay.
Cover sheet of the plans.
I have found where the PP indicators are now. All right, I've got PP1.
Well, I know that this
Oh,
conversation.
Give me just a second
Sure,
to put that on the screen for the folks.
In particular, if you want to zoom in, looking at the area north of Lot 1, basically the far northeast corner of the project.
So northeast, that's where the kind of separated 4 little lots are down
Yes.
there.
Yep. Mhm.
Give me a second on this because controls on my ship are not working the way I would like them to necessarily.
And just to be clear, today I'll just bring the issue up, recognizing that there's a larger conversation to be happening around this at the appeal for the MDNS.
I zoom up and I try to get the area in question up on the page, and then it jumps many pages on me. It's just a second ago, but now I got it working right. Okay. I'm holding on the area there.
So just to speak to it, because it was brought up by the public commenter, we are proposing our full frontage improvements along East D Street, which would end effectively at that northeast corner next to Lot 1. However, the city, as part of the MDNS, put in a condition to extend sidewalk on the west side, our side of the street, an additional 460 feet north to a paved path that goes into the park but does not connect to the regional network of sidewalk at large. So it's effectively a 460-foot sidewalk to get into the park. And so while on the opposite side of East D Street, the important part for and I'll speak to this mostly because we're going to save the other conversation, but the opposite side of East D Street has full sidewalk, and we're building all of the curb ramps at 4 intersections south of here. We're building all of the sending and receiving ramps. So effectively, anyone leaving this neighborhood could walk across D Street and travel all the way up to 72nd Street on the east side of East D Street. So in the way of pedestrian connectivity to the larger City of Tacoma network of sidewalks, there is massive connectivity available. Whether that connects with a specific sidewalk to a trail within the park, again, that's our contention is that that's unnecessary. It's over ask. Again, in light of the fact that we have 2 trail connections effectively to the park already being proposed, one passing through where the city sewer easement is, and the other again right next to Lot 1, 2, 3, and 4. So there are ample pedestrian connections to Blueberry Park from our project that wouldn't necessitate an additional 460 feet of sidewalk. So that's again speaking directly to the public comment that was made, knowing that we'll have a larger conversation about whether that the nexus and proportionality of that request is reasonable. Let's see. Just kind of going through the items here. So then other than that, I mean, those are the kind of rebuttal to public comment, but we do have some commentary on conditions, and I'll go through them one by one. The first is in the staff report, condition 5.
Let me get to that.
And I'll read it before
in front of me. You can read it to me, but I'm too much of a visual
no worries. Yep.
person anyway. And if I get it on the screen, then the folks remotely will.
See, I'll read the first part here. So a 10% tree canopy coverage requirement for the developed portion of the site, calculated based on the developed portion of the site only. The approximately 10 acres to be developed portion of the site shall be required. The method of calculation shall be the standard in the City of Tacoma Land Use Code at the time of development. While this condition will not need to be met until the time of development, it is being placed as a condition of approval PRD to ensure tree canopy remains on the site in perpetuity. It is history that perimeter street tree placement, non-critical area, open space trees can meet this requirement. Trees within utility tracks along trails within the development portion of the site can also contribute to this requirement. The calculation will be required on the landscape plan at the time permitting. So it is our, again, recognize failure to recognize this site as a whole. 28 acres is unacceptable, and so in our contention, we are preserving over 60%. Again, roughly 18 acres of tree canopy, which far exceeds the requirements and meets any public benefit test as to whether this is worth it, whether this kind of meets the standard of a PRD to again preserve 60% of a site in vegetation with additional plantings up to 3,000 trees. This is an additional requirement now that we would prefer to have removed from the record as a condition of approval. That being said, we recognize that street trees and landscaping on the site will likely get close to 10%, but that calculation should not. We just feel like that calculation and doing that mental gymnastics to meet some percentage, some arbitrary percentage when we're already significantly over the standard is again relatively arbitrary and should not be required of the project. I can pause there and we can talk about that, or I can move on to the other conditions that I have concerns about. What would you prefer to do?
Well, a hearing like this isn't necessarily a round robin discussion, so you said your piece on it. I don't have any questions for you on it at this point. If Mr. Harala has rebuttal for it, we'll take that in its turn.
Perfect. So then condition number 10 is in regard to our mitigation plan. And I'll go ahead and combine condition 10 and 12. So 10 reads, the applicant shall monitor the mitigation areas for 10 years and provide a monitoring report for the city in years 1, 2, 3, 5, 7, and 10 by October 1st of each year. Should the performance standards fail to be met during the monitoring period, contingency actions and additional monitoring will be required. Condition 12 reads, the mitigation provided will be maintained in perpetuity even through formal reporting to the city. Even though this formal reporting to the city is not required after 10 years, continued maintenance is required to be kept to keep the mitigation areas compliant with the mitigation proposal approved. So our issue here is not with the conditions themselves, but specifically with the length of time that monitoring will be required. Typically, a 10-year monitoring period is for wetland creation, wetland fill, pretty significant impacts. Whereas in this case, we are providing mitigation to improve the function of these wetlands. City code says it requires 5 years minimum. That is a typical wetland monitoring period is 5 years. If this development is not meeting the development standards or the standards for mitigation at the 5-year mark, the city certainly has the ability to extend or basically deny the release of any kind of financial obligation or monitoring period. So it could go as far as 10 years. However, the city code says 5 years. There's no justification for 10 years here in our opinion. So we would prefer, or we'd ask that both of those conditions be limited to a 5-year monitoring period. And Jeff may have more input on that than I have.
Yeah, I think that was well said. I think the success of the mitigation area is dependent on the performance standards established in the report. So 5 years for monitoring, you still have to meet the performance standards. In other cases, in other jurisdictions, if we've met year 5 performance standards at year 3, because we've done such a good job at maintaining the site, doing the proper prep, planting things at the right time of year, watering and doing irrigation when you need to, doing maintenance as at a regular schedule, you can get the bond release. You can stop monitoring after 3 years sometimes if you meet the performance standards. So the performance standards in the document that we prepared is pretty rigorous. So to me, it seems like an overreach to include a 10-year monitoring requirement. Only because, as Evan indicated, that's typically reserved for larger impacts.
So let me ask a question then. Copperidge LLC builds up this townhouse development. Came up in the AM. It's not like the prior proposal with the prior owner where it's going to be long-term leasing situation. You're going to be selling these townhomes to buyers in fee who will own them. There's going to be an association. Are you planning to condominiumize this?
It's a plat, a fee simple plat, just like a single family detached home would be.
So each individual lot that's going to be platted will be owned by that townhome, essentially sort of in a zero lot line for the buildings, whether it's 4 or 6 units or whatever. And then all the common areas,
correct,
that aren't part of those lots, those will be owned by the association that you're going to form.
Correct.
What about all the wetland areas? Everything, the 18 acres that's not the 10, is that all going to be HOA owned ultimately?
Yeah, and that's actually in this document, as one of the conditions of approval, that the HOA be established,
right,
and own and maintain the wetland buffer.
And I saw that. So that's all sort of foundational from me to say that on a 10-year requirement, it's highly likely that Copper Ridge LLC is going to be out of the picture before 10 years, right?
Very likely.
So it'll be the HOA who's taking over these maintenance obligations out to 10 years or even 5 years, really, if the development goes as quickly and the sales go as quickly as Copper Ridge LLC would probably like it to be. You'd be out of the picture maybe even in 5 years. A little ambitious, but definitely by 10. Correct?
There's a probability that the maintenance after 5 years would fall on HOA.
And I guess we'll see whether the city has any rebuttal on the necessity of the 10-year period when we get to that point. But yeah, anyway, I asked my questions. So.
Okay. That's related to conditions 10 and 12. So any change to condition 10 to limit it to 5 years, with the caveat that the city is capable. There's nothing to limit the city from saying we aren't going to release the bond because you haven't met the performance standards. It could go as long as it has to. It could go 12 years. It's up to,
each report has to be reviewed and approved by the city. It's not like it's a submission that we did it.
Yeah.
Well, it's kind of a path fraught with peril because LLC gets formed to handle a specific development, and 5, but especially 10 years down the road, the LLC itself might not even be a going concern anymore. So I'm sure the city's aware of that, right? Anyway.
Okay. I guess we'll save rebuttal. So
next
condition 16, I point to as a condition that we have asked the city if they would be willing to accept a bit of a change in the language. Effectively, our concern there, and I think the city's critical areas reviewer would be able to speak to this as well. Our concern there is that it is overly prescriptive to meet a post-development flow and hydro period that both the stormwater manual and the critical areas code have flexibility through either storm development or critical area development permits or stormwater drainage adjustments. So we just want to make sure we're maintaining those flexibilities. And so our language, effectively, we would just like to state that if the post-development flows and hydro periods cannot be maintained, all abilities to seek wetland development permits and drainage adjustments as necessary remain available. Again, just this with the language shall comply with these items. I just want to make sure that again we preserve the ability to seek those flexibilities that are in those code sections and that they aren't lost.
I wasn't taking dictation when you read off how you'd like it to read. What I would like you to do is post-hearing, put that down, and even an email is fine, but put it down how you would like 16 to read,
okay,
and submit that to me and Mr. Harrell, to my office, Mr. Harrell.
And I did submit it earlier this morning. I meant to submit it earlier this week, but I believe Mr. Harrell and Ms. Kluge have those in hand, so I'll get it to the hearing as well.
Okay.
Continuing forward, looking at condition 31, 31 is only really a concern for us in as much as it relates to the appeal that we'll be hearing for the MDNS. 31 basically is saying that we would need to do directional intersection 88 ramps at 75th, but we have no intention of doing any work at 75th because we don't believe that the extension of sidewalk on the west side of East D Street is warranted, and furthermore to require all 4 intersection 88 ramps at 75th to be developed is again overreach. So previously the examiner talked about potentially reviewing the plat separate from the appeal, but I think that there's enough conditions that are intertwined that it would warrant having a joint approval or recommendation.
I've come around to that particular religion as the days are.
Okay. Next is condition 35G. Really, this one isn't a major concern for us, but one of the condition reads, traffic calming such as speed humps or similar device should be constructed on the 8,000 block of East B Street, 8,000 block of East C Street, 8,000 block of East D Street, and 200 block of East 82nd Street to address cut-through and increased traffic. The city engineer shall approve the design and locations. Notifications shall be provided to the residents on each block regarding the placement of traffic calming prior to construction. So again, these are pretty significant off-site improvements that, based on the analysis provided in the traffic study and what has been brought to date, don't necessarily seem warranted. The condition of some of those streets also wouldn't necessarily be really a traffic calming device location. How many traffic calming devices? There's been no discussion. It's a very open-ended condition, and kind of a surprise to us. And so again, we would move that this condition be removed, as there's been no clear. And especially East 82nd Street is a block to the south with limited traffic from our project being sent to it. So again, feel like condition 35G is kind of amorphous and unwarranted. But I don't know if Aaron, if you have any discussion points on that.
Yeah, well, just I guess the language doesn't really define exactly the locations and where, East B Street, East C Street, those are all about 500 feet long before it intersects with 82nd. So they're not even, they're pretty short. You're typically spacing these devices out every 500 feet. And so it just wasn't quite sure the nexus on some of those requirements.
Also, just to be clear, the intersections that are being built by Copper Ridge along the north, along East 80th Street, will have bump outs, which will be traffic calming from our development, leaving our development onto any of those surface roads. So again, there already is traffic calming within that 500 foot measurement that would prevent traffic from reaching excessive speeds by any means here. So again, either move to remove condition 35G or get more clarity from the city as to what that would entail. But it should be noted that there was no study done or no justification provided stating that this was an impact from the city. And so again, just kind of a surprise to us. And then the last item actually isn't a condition of approval. It's kind of an odd thing that we see here, and I don't think I've seen any other city do it. But essentially, everything after condition 54, the city has stated as advisory comments for future permitting. We feel that those are inappropriate to be put in as conditions of approval and should be removed or placed in the staff report in a different location, but certainly not in the decision of the hearing, unless they are to be forced upon and acted upon as part of the conditions of approval. So that's kind of the last item that I had speaking to the conditions.
I often weed out stuff that's advisory and leave it out. In my most recent one, I probably left most of that stuff in. but I always use lead-in language to that says some of this stuff is just advisory. And by the way it's worded, if you have something in there that says, hey, if you need more information about water hookups for everything, call this person. That's obviously not a condition. And oftentimes I weed those out. I think in the last plat decision that I issued probably a couple of weeks ago, I just left it in and had my caveat language at the front.
We just noted there was a break at after 54 and before 55, and staff noted it as well. That
Yeah,
those
and
were
I
all,
think Mr. Harala contacted my office and indicated the same. So if it's not worded as a condition of something you have to do, chances are with this one, I'll probably just read them out. And the language that I put in there in my plat decisions usually says, the fact that I took something out that was in the condition section in Exhibit C1 does not mean it was in conflict with this decision. It just means that it was probably advisory only, and it's still a good idea to take advisory things under advice and follow that advice most of the time.
Sure.
But if it's not a condition, it's not a condition. And even if I were to leave it in, you're not going to be back in front of me for violating something that's not a condition. So if you were, I'd just say, what are we doing here? It's not a condition. Why are you wasting my time today?
Yeah, and
So I understand where you're coming from.
Our only concern there is, again, just how staff changes happen, how different things get looked at. A clean record is an easy record to speak to work towards, and so just as much as we can. Again, we appreciate the advisory comments.
Staff does tend to kitchen sink that section of the staff report, so I know where you're coming from.
That is all from the applicant and our presentation. Appreciate everyone listening.
Is there cross, Mr. Harrell? Or is it rebuttal? Or is it both? It
I
can be
think it
both.
may be a little of both, and
All
if you will kind of indulge me a bit here to kind of double check what I'm getting. And then can I ask maybe a procedural question before we even get to this?
Sure.
So given that it sounds like I'm presuming going to keep the record open until we get
Until the
past.
MDNS is done?
Yeah, and
Certainly can.
And then potentially, it sounds like is there a request to do that with the rest of at least the plat and the plat conditions as well? Because
Well,
they may be sort of intertwined.
Like I indicated here just a moment ago, I'm really not feeling comfortable in issuing a decision on everything else without the MDNS being in hand at this point, at least with the hearing having been held. But I'm inclined to honor what I think was a request earlier, is to have them all issued at the same time. And that would certainly mean that we would have the luxury of keeping the record open until the MDNS hearing is done, at which point I would hope we'd be able to close it for everything. And then I finish writing for all of it and get it out.
So on that note, then then I guess then my request might actually be a viable request. So would we be allowed to rebut the written kind of requests from the applicant
at the
in
MDNS
writing? Not the MDNS.
Okay.
No, because what we have is there's 7, correct? Is it 7 out of?
Sorry. Turn the page over to take notes as I went.
3, 4,
Page got
5,
full.
6. I have 6. I have 5, 10, 12,
6, well,
16, 31, 35G, with kind of 7
7
with the
with the-
advisory stuff, with the fluff.
We could maybe save us all a little time and do, I think, all of us a favor and be more thorough. If we can do a written rebuttal to all of the requests, and then give staff a little bit more time. If that's amenable to everybody, but I don't know if that's.
I don't have a problem with that. If I were to put myself in the applicant's seat, though, what I would be concerned with from their standpoint, not that, and I'm not looking out for any one party over another here, because we'll balance this all out before we're done. But I would be concerned from the applicant standpoint that then you get the last word, not only the last word, but in writing, and they might have some additional things to say on that. Before I answer the question, what leaving the record open until we're done with the MDNS hearing, whenever that ends up being, if it's next Thursday or whenever we can fit it in. What that affords both of you is time for you to talk more about those conditions to see if you can reach an agreement on. You certainly don't have to. I'm not going to force you. I can tell you have to do it. You might not come to any kind of an agreement anyway, just because you're not inclined, because I don't oversee that process. But it does afford you the ability to talk some more. And as happened with the hearing back from August 29th, if you can reach an accord on some of this stuff, then you can just submit that. And then if there are revisions that are made that are agreed upon, then I can certainly add those in. Unless it's a really odd case, which I can't imagine happening, where even though the parties have reached an accord on it, I'm looking at it and seeing it differently, and either want to keep it the same or do something entirely different than what you've come up with, because I can. Again, as long as there's that nexus and it's proportional. But it does give you the opportunity to do that, for you to talk. I don't have a problem with you submitting rebuttal in writing. If you find that you can come to an agreement on it and you submit that instead, that's perfectly fine as well. Depending on what I get from you and the level of it, they're because they carry the burden of proof, I may give them the opportunity to respond to your rebuttal. Okay. The party with the burden of proof, typically in virtually all legal proceedings, gets to go first and last usually. That was a big shock to Donald Trump in a recent trial of his in New York, but
I will
that's
have
the way it
we
works.
do have two. I would like Carla and I'd like Jennifer Camersell to have a chance to verbally rebut. But I think on some of the other issues, I can speak.
Well, I'd like to do one or the other. If they're going to address it today in testimony, that would be it. If we want to forego that for the opportunity to submit written rebuttal, we'll do that. I don't want to do both.
I'd want to limit.
Go ahead.
We would want to limit rebuttal and further testimony and record, keeping the record open to those items if that's possible.
Just
So instead of, just to these specific.
Yeah.
I guess we wouldn't want the record left open for
No.
all kinds of whatever anything else can come up with.
No,
We
it's
want
not.
it to be
It would be
remain to
limited,
those,
yeah,
and
it'd be
then
limited to those purposes. I don't see any other reason to keep it open
Sure.
for anything else.
And then we would certainly want if we're, I guess we would certainly want the ability to respond. There's almost no circumstance where we would not at least have that reserved ability
I
to respond.
understand you're taking that position, and I'll look to see what the city submits. Again, you guys can talk in the interim and try to work it out. And if you submit something like that, then that's fine.
I would note we did talk prior to, and these were brought up prior to the hearing. So there is relative understanding that there was a consensus at the time. We can go another round. That would be we can do that.
You can, but Boeing and its machinists at some point will agree too. But all that is to say that nothing is ever truly intractable until it becomes truly intractable. And where there's a joint interest here, where there is, because I think the city would like to be a reasonable regulator and find something that works that still achieves its purposes. I would imagine there's room for that. If there's not, there's not. Then you submit your rebuttal. I'll take a look at it, and probably a 95+% chance that I'll give you the opportunity to respond as the party who carries the burden of proof in this. And then you'll be last. The party who doesn't have the burden of proof usually doesn't get the last one. And that's the city.
So then I'm getting some feedback here. Give me a little leeway, if you will, please, Mr. Hearings Examiner. So I think that if it's allowable, we're absolutely concur that we don't want to keep the whole record open and rebut the whole thing.
Well,
absolutely
and
narrow
that's
it,
my call, and I'm
narrow
not
it completely per your
There's no way
direction.
I'm keeping the whole
Yeah.
record open.
We can narrow it. And I would include in that the advisory conditions as one of the items. I'm more than happy to amend the staff report and renumber or even in a more.
I don't
clear
think you
way.
need to do that for the advisory conditions.
Okay.
You certainly can if you want, because we talked about maybe making a few corrections and
Yes.
resubmitting earlier in the day. And if you want to do that, I would encourage it. If you decide to take the advisory stuff out, I'm okay with that, but you can leave it in because, like I said, probably 9 times out of 10, with this type of a hearing, whether it's plat, whether it's a rezone, whatever, where there's a whole bunch of city conditions, and a lot of them end up tending to be more advisory than actual, they're hortatory, not mandatory, I guess is how I would divide the two. 9 times out of 10, I leave now. And I hope, well, I guess in the end, they don't really care. I hope the city doesn't have a problem with that, because if something's advisory, it's advisory. And there can be confusion, which I think was Mr. Mann's point about his comment about a clean record. There can be some confusion sometimes because of the context in which something is included, even if it's not, even if it's an orange coming on a tail of all the apples.
I will work to make that as clear as possible and follow your advice. Though I'd leave it in, but maybe we'll relabel it or insert a statement at the beginning just to make it very clear for future staff.
Seems like a good place would be to move it up into the staff findings versus in the conditions of approval, just based on.
Well, most of the stuff that's in that area of a staff report usually isn't really a finding either. So I get to make that call too. I can make all the calls eventually. So where we were at was, I was asking whether you had cross-examination for the testimony that's just been given. And I guess it's a 2-part question, which can be objectionable under the rules of evidence, but that's okay because I'm running the show. The first part was, do you have cross? The second part now is, at this point, are you going to want to call rebuttal witnesses on some of this, or do we want to do written rebuttal?
I would ask if on one of the conditions, and maybe this can take it out of the mix, depending, but definitely I would like Carla Kluge to call her on number 10.
Condition 10 and 12.
Yeah.
Okay.
So she would like to talk to that.
Before that, though, there's the cross question.
I do not have any cross on these items.
Okay. So then, different question. Is the applicant done with his presentation? Before we move on then to what will be a rebuttal witness in Ms. Kluge.
Yes.
Again, going back to your statement that the applicant gets the final word, if Ms. Kluge's rebuttal is of concern to, again, we brought our.
You'll have the opportunity to cross her, and if you have some rebuttal there with that, we kind of go a little bit out of order, because by hearing examiner rule, we have the city go first and make its presentation, even though they don't have the burden of proof, but I will give you last. Okay. So if you have some rebuttal to what Ms. Kluge has to offer as part of the city's rebuttal, we'll do that briefly.
Thank you.
All right. So we're calling Ms. Kluge.
Yes, if we could, please, Mr. Hinks.
Let me stop the screen share so I can get her a little better on the screen.
Should be in the Zoom meeting.
City staff, folks, I presume you're still hearing me all right?
Yes.
Okay, and you just came through with that answer loud and clear, so that's good. Ms. Kluge, would you raise your right hand on the screen, please? You swear and affirm that the testimony you're about to give as part of this proceeding day would be the truth, whole truth, and nothing but the truth, under penalty of perjury?
Yes.
Okay, so how are we going to do this? Are you going to ask her questions, or are you just turning it over to her?
I would like Carla to just make her statement. I think she has statements she would like to make.
Okay, and we're limiting that to conditions 10 and 12 for the most part. Is there still going to be a written rebuttal after that from the city?
If we can have the leeway to do so, we would like to, but I think it's important enough for us to have Carla speak. Then on those, this can be our rebuttal.
Well, let's hear what she has to say, and then we'll address the issue again. Let's see where it goes first. So go ahead, Ms. Kluge.
Okay, thank you. Yes, I just wanted to offer some additional information on condition 10, the condition that is asking for monitoring for 10 years and the reasons that underlie that request. The 10-year requirement, although yes, it is used for wetland creation and wetland fill, it also is best available science that the critical area code does point to. And in fact, the Department of Ecology in their last mitigation monitoring guidance includes statements that say monitoring should be for a period of 10 years. So that is part of the underlying best available science where that conditional requirement comes from. I also want to provide for the examiners consideration that usually or routinely the city does require monitoring for 7 years on slopes, again, toward best available science from arborist recommendations. And that, again, the 10 years has been used for other developments where significant trees or huge areas are going to be restored. In addition, the applicant did propose 10 years for monitoring the trees, the many trees that are going to go on the site to replace the significant tree loss. And in looking at the site as a vegetation community, I did think that having 10 years to look at the vegetation as a whole, or however the monitoring is set up for transects or specific counts for the trees, is very appropriate. Also, the mitigation is primarily buffer. However, the wetland does come very close to that easement that goes through between the wetland area and the developed area, and some wetland area may actually be planted as part of mitigation. Although it kind of looks like a buffer, it may actually be a little bit of wetland area right on the edge of that center trail.
The easement you're referring to is the city's easement that bisects the site?
Yes. So I thought that it was important to point some of those things out with regard to why 10-year monitoring has come into play here. And so that's what I wanted to offer on that condition. On the other two critical area conditions that the applicant noted, condition 12, which is the mitigation will be maintained in perpetuity, and the other condition regarding stormwater to preserve amphibians, I'm more than willing to discuss alternative language in there that may still work for both of us. I did have a very brief conversation with the applicant, and there may be a solution there that will work for both of us, so it's not truly a rebuttal, more of an agreement to take another look at the language in those two conditions if the examiner finds that appropriate.
Yeah, and I've already said we're going to have some little bit of intervening time, so the parties can certainly do that. I'm not precluding that at all. So
yes, so that rather concludes what I wanted to offer.
Does the applicant have cross-examination questions for Ms. Kluge on her testimony?
Where in code, Carla, do you find justification for 10 years?
Oh, it's under the best available science. Our code points to best available science. I don't know the actual code citation, but I can certainly make that available.
Does that code area that points to best available science include the actual reference science, or is it just any science that comes out whenever it comes out can be now deemed best available and can be used to change this standard to 50 years?
When science comes out, if it can be backed up by peer-reviewed papers or actual guidance documents issued by the Department of Ecology, yes, it can be the most recent science requirements. Which
but
today
there is no specific action in code other than 5 years.
Yes, the language actually says minimum of 5 years.
Right. And yeah, so and there's nothing in that timeline that's scientific necessarily. That's just a timeline that they would want. I mean, the monitoring, best available science would say that it should be monitored for the rest of its lifetime. Correct? I mean, it should be any invasive species or trees that are planted should be well maintained and monitored through their entirety. Really, if you want to look at best available science, is that accurate?
It is accurate to a certain extent. Certainly, mitigation banks are monitored forever. Mitigation is essentially required to be monitored and maintained forever. It is not a requirement that we impose on an applicant to monitor forever. We look at guidance requirements and the science that is available from the Department of Ecology. That would be the main source of documentation that we look at. And again, their recent mitigation monitoring guidance documents point to 10 years. And we've been doing that for at least 3 to 5 years.
But without any code justification for that, other than just pointing to what hasn't been provided in the record, any sort of best available science. There's been nothing that's been provided to in the record that would suggest that you pointed to a piece of best available science stating that this needs to be monitored for 10 years. Again, a code is the only thing we can.
There's your testimony under oath now.
Okay. And no more on cross, then I think we do have some commentary rebuttal if available.
Additional testimony, Ms. Kluge? Anything to address that's come up in cross?
No, I have nothing else.
Let me
I just want to make a quick point of clarification if I
hang
can.
on. Me first.
Sure.
You mentioned that some of the best available science that you're looking at now for the 10-year period had come from Department of Ecology. Is that correct?
That's correct.
Is there a publication that mentions that? Or how
Yes, there
are you
is.
getting that from Ecology?
Well, I go to the ecology website, but there are recent publications and guidance language that's being provided through their website and recent publications. And I can certainly provide I don't remember them off the top of my head, but I can provide those to the exam.
If you can provide that to my office and to the applicant, that would be, well, I won't just say appreciated because that leads you to not garner my appreciation. I would like you to submit that, please.
Yes.
Fine. If you can find it. If you can't, then you can't. And that just then gets weighed in the balance. But if you can find it, it would be beneficial to me. And in cross, you've been asked about it from the applicant anyway. So if you can provide that, that would be requested at this point.
Yes, I will.
Thank you. All right. So some rebuttal then from the applicant. And you know, in scope, you should be limited to what has been testified to and elicited on cross. So still under oath.
Yeah, I just wanted to make a point of clarification for the mitigation. Our mitigation planting plan specific in the report that was approved by the city for the preliminary approval refers to 5 years for the overall planting plan. The 10-year reference is specific to loss of significant trees as a result of the clearing. So those are two different requirements. Not all trees we plant are going to, based on if they're requiring 10 years in the end as a condition, then it will be 10 years. But my plan didn't say 10 for everything. It said 5 for the restoration plantings and 10 years specifically for the loss of significant trees.
So
just the language is different.
That's on the 10 acres that's being cleared.
Correct.
So what specific trees are the ones being planted to address that loss of significant trees?
I think it's a 3-to-1. I'd have to look at the report.
Are they going in the undeveloped area, or are those going? Is that going to?
They're going in the undeveloped area, not street trees, native trees. Yeah. So there would be specifics, and there's also typically, if we're doing this just might not matter, but they're usually larger than the standard trees.
So for those specific trees, then you're not objecting to a 10-year law?
No, because that's how we wrote it.
So I would add this, that as it relates to conditions imposed on a project by the city, we expect an objective target. We expect that these things are in code. DOE has different buffer requirements than city. A city must amend their codes to include these types of regulations and standards. Otherwise, we have no objective target to work from. And essentially saying best available science is the overriding, that, well, then you could say your whole critical area code is subject to change at any given time because best available science says it is, versus having it written specifically in code as a standard. So,
and codes are updated and changed all the time.
Right.
And best available science is a condition. And, it sounds like to me that you're saying if it isn't in code, you can't impose it. And that's entirely not true.
No.
Because, again, we're back to the realm of next proportionality. The director And when it's in front of me, either on appeal or of first instance like this one, both of us have the authority from the code to condition things with reasonable conditions, then again, against that constitutional backdrop of next proportionality. So to say it has to be in the code is not a correct statement of the law from my standpoint. And I'm the one who decides that at this point. But it does have to be, I get what you're saying about, we have to have an attainable target here. And that's what Ms. Kluge, I think, is testifying to, saying 10 years of maintenance based on that being the best available science, and best available science being a reference point in the code as its origin for coming to that, because that is now the best available science.
So I would point of clarification, the document that she's referencing as the mitigation in Washington State, the update, I think it's 2019. That is a guidance document that's released by Department of Ecology as best available science, recommendations to jurisdictions to consider and adopt it. There's a whole series of different mitigation standards that can be considered for buffering, for monitoring. They are moving in this new version to the 10 years as what they're recommending, but it's a guidance document. It's not a regulatory document. That's what I would want to add.
Yeah, I understand.
Okay. But I guess my question is, at what point does it need to, I mean,
and I'm not saying I'm going to uphold the condition.
Sure. Just wanted to clarify.
Still, I'd love to see you talk in the interim between now and the MDNS hearing and reach an agreement on something, because, before I became the city's hearing examiner, I would always tell my clients, if you can work it out, it's a whole lot better because you found something that both sides are able to live with. If you don't, then you get whatever I spit out. So,
well said.
Fair.
Thank you.
Mr. Examiner, I just will disclose to everybody, my battery's gone, so I no longer have contact to my team, but we're fine. I think everybody's okay.
And that's okay. I usually don't like to have a whole lot of phone a friend going on during
yeah.
this,
I mean,
which
normally
both
wouldn't-
sides have been.
You know how it normally works. I would just be doing this kind of, and that's how kind of we operate normally.
Yeah, there's a fair amount.
Carla,
of
I
discussion at the
believe,
tables.
may want to just make any kind of quick comment. I mean,
Well, I think we're past that at this point.
Okay.
They got the last word. We have still left open the possibility of written rebuttal. And the written rebuttal is limited to the conditions and the challenge that the applicant has made to those. So I don't think they've actually given you anything else really to address at this point. So it's limited to that. If you want to submit written rebuttal on those at this point, still, that's fine. If you all get together and decide that you've reached an agreement on them, that's good too. And 95+% chance, because the applicant carries the burden of proof, I'm going to give them the last word on it. Do you still want to submit written rebuttal?
we'd like to reserve the right, but I think, so may I ask a question then of you and the applicant too, through you. If I'm hearing right, we'll receive the written 6 or 7 items. We will try to schedule a meeting.
Sure.
Talk, and then we will, we would like to reserve the right on anything we can't come to an agreement on to rebut that. So perhaps we whittle this down or even come to a resolution on everything. And then there's no need to go through this exercise.
Well, yeah, if you reach an agreement, there's nothing to rebut. You just submit what you've reached the agreement on. And then, like I said, and except for the very unlikely chance that I see what you submit, I just say you're both crazy and I'm not going to do that. I'm going to exercise my authority to impose what I decide works, which is unlikely, but could happen. Then you do that. So yeah, I mean, if you reach an agreement, you reach an agreement. If you don't, submit your whatever additional information you want to rebut on this, and then I'm going to give them the last word on it.
Condition 31, though, is related specifically to our SEPA appeal.
Yep, that'll be addressed in the appeal.
Held separate then from, so it would actually be 6 items that we would be discussing. Condition 31 would be separate.
Yes. And you said 6 things coming in. They've already come in. They already identified all of them. The only thing I think we've got something coming in on is condition 16, where you read, and neither Mr. Harrell nor I were taking that down word for word. So you're going to put that into for printed type electronically or whatever, and send that in so that I've got it so they can consider it.
And Miss Kluge was very clear that she was open to having a discussion about what that language should be. So that was my first draft at something, and I think we're happy to talk with the city to come to some mutually beneficial or helpful language there. So
perfectly happy to let you. I think we're done. What? Thank you.
Can't we go a couple more hours?
Well,
I have to go back to the office. Just kidding.
I have to jokingly say that I'm one of those people that was born without the meeting genes. So whether it's a meeting, whether it's a hearing, anytime it can go shorter than what I was actually anticipating it to go, I'm usually a happy guy. And you could ask Louise, I'm never happy. So you could ask the people there in the city of Tacoma staff room, probably at least 3 out of the 4 of them who used to be clients. They would tell you I'm never happy too. So you can make a closing statement, a closing argument if you would like to do so at this point. We didn't really have formal opening arguments. That doesn't mean we can't have formal closings. If you would like to do that, you can at this point. And for that purpose, I would have the applicant go first if you choose to do so, then the city, and then you would have the opportunity for rebuttal closing if you wish to do so. It can be waived.
Closing statement would be this from the applicant. The city of Tacoma staff has been very great. I think there are some simple things like the SEPA determination happening or appeal happening 2 days. There are simple things in code and standard that I think that staff is doing their best to work with, and some of our frustration is more related to those specific issues in code that we work with the city to help fix. But that, otherwise, we appreciate staff's efforts. I mean, Larry's been shepherding this thing all along, so we really appreciate staff and your example. Closing discussion there.
Any closing from the city then?
Yeah, just a real brief, very similar kind of feelings from the city. I think the applicants worked really hard on this. We look forward to a good resolution here, hopefully, on the remaining issues. That would be our closing.
I'm presuming you don't need to rebut that.
Nope, no rebuttal.
You'll tell me if I'm wrong.
No, I don't take that.
Okay, so we do need to sort of map things out procedurally from here, and I may even put this in a email just so we've got it in writing. We're on the same page. If I get really crazy, I'll put it in a post-hearing order, but probably not. We're done with the hearing. We're leaving the record open only to address the challenge conditions 5, 10, 12, 16, on which language will be submitted. Condition 31 will be addressed in the MDNS appeal in detail. And then 35G, because the MDNS appeal is getting continued out a bit, the MDNS portion of the overall appeal, that's how I'm going to phrase that, because I like it that way. That'll be on the record if you make it the continuance an issue on appeal to Superior Court or something. This probably won't happen, but you never know. Because we're continuing that out, that gives you opportunity to discuss. But the record will stay open until then. I'm going to leave that record open until we are done with the whole of the hearing, which the last segment of which is the MDNS appeal. All right. When we get to the end of the MDNS appeal, we'll either close the record just period for good, or if there are still some things that need to be submitted at that point, we'll address it then. Okay. But I think the parties need to anticipate that the things for which we are leaving the record open on this stage of the hearing will, in all likelihood, need to be wrapped up at the end of the MDNS appeal. Which brings us to the MDNS appeal. You confirmed that Mr. Victor, counsel for the city, is available on the 17th, correct?
Correct.
Okay, and the 17th is next Thursday. I need to bring up my calendar here quickly. All right, so that is next Thursday. Oh gosh, you've already put a placeholder on for this. Thank you. Is that going to work for the applicant?
I believe so. If we decide to bring legal counsel on, how would that change, if at all? Just let them know.
Give me a notice of appearance as soon as you've made the decision. And that's perfectly fine if you do. Just tell them they need to send it. They need to file a notice of appearance with my office, and they should know what that is. If they are actually an attorney licensed practice before the bar and they don't know what a notice of appearance is, you've got a problem.
No,
I'm guessing that won't be the kind of attorney that you're going to hire to represent you on this if you do. You don't have to. You know, anybody can be pro se in front of me if that's what they choose. But if you have counsel, that's fine. Okay, let's get the NOA. Is it going to work for the city? It works for your council, but you said that some of your staff is going to be away.
I don't have everybody on screen here. I can't say 100% for sure. I will make, myself available for sure. We have a conference, but we can easily do, if we're on Zoom, we're fine.
Okay.
I don't know about everybody else. And then I also just have the question about, we're going to try to meet these other issues. The ideal if we do that before the MDNS and we want that resolved. So the question.
That's what your mission impossible is between now and next Thursday.
Yeah.
So are the parties agreed that we're okay in conducting that last segment of our overall hearing, the MDNS appeal, over Zoom?
Yeah.
Don't have to come to council chambers. Don't have to deal with the constant
Council chambers. I thought we were coming back here.
Right, yeah. If it's here,
well, we could, but I got so much better setup at home to run these things from there. I'd much rather do that. See, I mean, this little thing. So I have two screens paid for out of my own pocket to use and do, which means, when I retire, if it's still working, it's going with me. But at home, I have a big 32-inch screen and another one that's only slightly smaller than that. Separate mic, headphones to separate productive audio from receptive audio. So there's never a feedback loop. There's no problems, nothing.
So much better.
I have so much better system at home that I would much rather conduct it from there than here and, have my Band-Aids, as I call them. So are we agreed to conduct it over Zoom then? All right, so we will set that meeting. We will send you out the information for that. City, you're going to need to check with all your witnesses and make sure that that's going to work for them. If for some reason the 17th is not going to work, you need to let my office and the applicants know as soon as possible so we can consider other days, because we could do it on the 16th. If we're doing it over Zoom, we could go next Wednesday. I had a code enforcement omnibus calendar on that day, but they have put everything off until next month. So Wednesday is clear. We could do the 18th on Friday if we needed to, but we need to shoot for the AM, which brings me to the next question. What time do we want on the 7th? Assuming we're going to do this on the 17th, do we want a 9 a.m. start time, or would you rather start in the afternoon? I'm thinking this MDNS appeal is going to be kind of like a half-day sort of hearing. Am I wrong in that?
That would be good.
And if we do start at 9, then we can go over if we need to. If we need more than a half day, we can do that.
It's a pretty limited scope. I think we should be good.
Yeah,
Get it done.
that's what I'm thinking. And I will offer this too. In the interim, the city and the applicant can talk about the MDNS stuff too. If you reach a resolution on that, I will likely consider it and adopt it if you do. So 9 o'clock. 9 o'clock, city?
9 o'clock, and I'll have final word. I will promise, a big promise that by tomorrow, first thing in the morning, I'll have word 100% on if there's
Whether the
some
17th will
unforeseen
work.
conflict with other staff. So
Okay.
So, with regard to staff, and I was talking Tuesday would be the soonest I could.
Tuesday be the soonest. Okay, I'll try by tomorrow morning. So I'll try to get a window on that.
Between the 16th and the 18th. The 18th is better for Mr. Victor if you have to go to different.
I'll get another ticket. So unless you guys validate parking tickets.
All right, so we're
Send it
done and off the
straight to the
record. Then we
examiner.
will see
Send
you
it to your
next.
office.
Not even for staff.
Well, the 18th is better for him.
No. If you have to go other than the
Next time.
17th.
Yeah.
Oh,
17th
Thank
is
you,
okay
Aaron.
for right
Thank
now.
you.
17th, all right. So we will see you all on Zoom then at 9 a.m. on the 17th, unless we hear
Yeah.
from the city.
Yeah, otherwise. Okay.
Larry?
Thank you, Mr. Anderson. Appreciate it.
Thank you for your
I like the bow tie,
presentations
man.
today, and we are
I
off
got it.
the
We'll
record.
be in touch tomorrow.
For sure.
I'll CC you on everything.
Sounds good.